with my lord's permission. More for being spoken to. Clarification and a few corrections are there, my lords, in the judgment recently pronounced by your lordships.
In which case?
The judgment, my lords, in
In spite of first agreement. Yes.
Page-wise adjournment, list number 2, page number 8, serial number 23 to 28.
My lord, sorry, my lord, serial number 21, it is compromised for 10,000 plus interest, my lord. Since I am out of station, my lord, with great difficulty I am appearing. Serial number 21 in second list, 10,000 plus interest. Vijay Kumar is appearing for respondent.
Then we will record that.
Yes.
We'll record that. Let it come. Yes.
Page number 9, serial number 29 to 36. Page number 10, 37 to 41.
serial number 37, my lord.
Huh?
Serial number 37. I'm for appellant. I place a
Serial
week.
number?
37.
What is the she called now?
37 to 40.
41.
Page
Yes.
10, my lord. I'm for appellant, my lord. I place a week's accommodation.
It's coming up for admission.
Please, ma'am.
Admit postal final hearing. Registry is there to call for the TCR. Yes.
Serial number 41, my lords. I appear for the appellant. The appellant counsel has undergone eye surgery today, my lords. Can it be taken up next week, my lords?
Next week at the request of counsel appellant. Yes.
Please, my lords.
Page number 11, serial number 42 to 46. Page number 12, 47 to 52. Page number 13, 53 to 56.
55, Lord. I am for the appellant. Seeks for a week's accommodation, Lord. Some inconvenience, Lord, in the afternoon.
Inform the respondent.
I shall.
No, you have to inform and then make a mention. We don't know what's there, urgency.
And I undertake, Lord. I have his number. I'll inform. I just tried to call him. He did not pick up. I'll inform him. Maybe 21st or 22nd.
Yes, just after vacation.
Interim order may kindly be extended.
Yes.
Serial number 56, my lord. I filed few documents which are not in the trial court records. I've served the copy.
Which case?
56, serial number.
56, Vijay Shekhar Gowda, MJ Alva.
Yes, I am for the respondent.
And I have to file few typed copies also.
This is marked after vacation. At the request of appellant.
Interim order may be kindly.
Yes. Call the list.
Yes. Page number, list number 1, part and matter, serial number 1. J.K. Shetty, for appellant, B.C. Shivane Gowda.
My lord, I am appearing for the respondent, my lord. Shivane Gowda is engaged with another court, my lord. Kindly pass over the matter.
Yes, next.
Serial number 2, Ravi Shankar Shastri Ji,
Appellant.
B.A. Ramakrishna.
This matter given on the last occasion, my lord, since the apportionment dispute is there, my lord, last said, my lord, the court will pass order, my lord. The wife and my 2 minor children are the appellant's claimants, my lord.
So now, after calculation, is coming to 24 lakhs 34,822.
Yes.
Oh.
My lord, as per apportionment should be as per the award of MACT, my lord, because R3 and 4 are the parents of the deceased. They are made as respondent in this appeal, my lord. Therefore, we cannot report
And
this.
even on the last occasion also, you are saying something on interest also.
They said, my lord, if in the Adalat, my lord, I should leave 2 years interest. But, my lord, since it could not be settled in the Adalat, my lord, court.
Yes, please come. Agreed with the orders passed in NEC number 31 of 2016 dated 2nd December 2017. The claimant is Mr. This proceeding enhancement of the compensation. The case of the claimant is that on 18/3/2016 at about 11:05 a.m., when the deceased was proceeding as a PN driver, the accident had taken place because of the rash and negligent driving of the driver of the offending vehicle. He was admitted in the hospital as inpatient and later succumbed to the injuries on 21/3/2016. The tribunal had granted compensation of an amount of rupees 9,89,222. Learned counsel appearing for the appellant claimant submits that it is a case of the claimant that he is earning how much?
20,000 per month was claimed income, my lord.
20,000 per month, and the court had taken
5,000 per month.
5,000 per month. He submits that even as per the table. As this accident had taken place in the year
2016, it should be 9,500 rupees.
16, the court ought to have taken
9,500.
9,500. Future prospects were granted, not granted.
Not granted.
Not granted.
And the court had also not granted future prospects. It is submitted that even under the other conventional heads also, the amount that is granted by the tribunal is on the lower side. Next paragraph. The learned counsel appearing for the respondent insurance company submits that the tribunal had rightly granted the compensation and there are no grounds made out for enhancement of the compensation. Next paragraph. Having heard so and so. The accident had taken place in the year
18/3/2016.
18/3/2016. It's a case of the claimant that is earning 15,000 per month and there is no evidence on record to show that. The court rightly had taken, the court in that view of the matter,
May submit.
as per the table.
There was evidence, my lord, but it was not accepted. Salary certificate and employer was examined.
We accept his oral say,
The
there was
trial
no other
court had
document.
rightly not accepted the evidence that is written before the court with regard to the income. As this is an accident of 2016, this court is taking the income at 9,500. And as he is aged
24 years,
24 years,
40%.
future prospects at 40% would come to 3,800. Then his income is 13,300. As how many are the dependents?
There are
1 plus 5, 1/4 deduction.
my lord,
How many?
1/4.
5 dependents, my
There are
lord.
5
one-
dependents.
MACT has deducted 1/5, my lord.
It should be 1/4.
Court, the tribunal had deducted 1/5. As there are 5 dependents, it has to be 1/4. If 1/4 is deducted, it will come to 3,325. And then his contribution to the family would be 9,975 into 12 into 18 would come to 21,54,600. Under the head of towards consortium, then what we'll go with the same calculation as per
40,000 each.
40,000.
48 it comes, my lord. 2 escalations, my lord.
No, 44 I think.
Please.
So 44 into 5.
220. 220.
Huh?
220.
What is that?
2,20,000
2,20,000.
rupees. I
Another
would like to be
20,000
fair.
is 54,000 it will become. Even this funeral expenses also another 6,000.
23,000 rupees extra.
So it will be 24,60,822 would be the amount. Towards consortium, 5 into 44, 2,20,000. Towards funeral expenses, 36,000. The trial court had granted 50. The tribunal had granted 50,222 towards expenses.
Medical
towards
expenses.
Medical expenses, and this court is not interfering with the same. Then another 10,000 towards legal expenses. It would come to, again do the calculation, 24,70,882. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 9,89,222 to 24,70,822. The enhanced amount shall carry 60% interest. The apportionment shall be as ordered by the trial court.
Please.
Till number 3, R. Shashidhara, appellant, YK. Teshgiri,
Second respondent.
Last time he was not there.
I was there, my lord.
No, the other
Eh,
part.
other side was there, my lord.
Then where is he now? Then in that case, we'll pass an order.
Yes, my lord.
The agreed with the order passed in MBC number 694 of 2017 dated 2nd January 2018. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 20 lakhs and the tribunal had granted an amount of
3,54,000, my lord. Page.
3,54,000. Land council submits that the tribunal had not considered the income at 7,500 and it ought to have been at 9,500. Even at the head of pain and suffering, the amount that is granted by the tribunal for the two injuries, for the two fracture injuries sustained by him,
Fracture of tibia.
granted at 30,000 is on the lower side. Further, the court had not had not considered the income properly, and towards the loss of amenities also, the amount that is granted is on the lower side. What about the disability? Same. As per
17.
the evidence court had taken.
Yeah, 17% doctor has stated, 11% taken.
The court had taken 11%.
Yes.
It is submitted that when the doctor's evidence is that he has sustained 17% to the disability to the whole body, court had taken 11%, hence requires enhancement. Expertal and counsel appearing for the insurance company submits are based on evidence court had rightly granted compensation and there are no grounds seeking enhancement. Expert, having heard so and so, considering the injuries that are sustained by the claimant, the grievous injuries under the head of pain and suffering, this court is granting 60,000. Then coming to the loss of future earning, the court ought to have taken 17% as disability, and without any basis, court had taken 11%. Considering the fact that this is an accident of 2016, this court is considering the income at 9,500. 9,500 into 12 into 14 into 17 by 100 is 2,71,320. Coming to the loss of earning during the later period, 9,500 into 3, 28,500. Loss of amenities, considering the disability of 17%, this court is granting 30%. Court had granted 1,25,000 as medical expenses, and this court is not interfering with the same. Coming to the attendant nourishment and conveyance, court had rightly granted, and towards future medical expenses, also no interference is called for. Accordingly, the appeal of the claimant is partly allowed, enhancing from 3,54,000 to 5,49,820.
6% interest.
Yes, next.
Cell number 4. Spurti Hegde Hen for
Appealing for appellant, my lord. Kindly refer this matter to local development. Kindly refer this matter to local development.
For respondent.
Yes, it's already over. Calculation is over. I'll pass the order. MBC, the present MFA is filed, seeking enhancement of the compensation. Filed with the claimant, seeking enhancement of the compensation. Agreed with the order passed in MBC number 176 of 2018, dated 25th June 2018. The claim petition is filed seeking compensation of an amount of rupees 30 lakhs, and the tribunal had granted compensation of an amount of rupees 1,80,000. The land council submits that the court had not granted reasonable compensation considering the injury sustained by the claimant. This court, land council appearing with the respondent submits that the compensation was rightly granted. This court, considering the injuries, that is CT brain, right temporal region, STH, small contusion with SAH, liver laceration treated conservative. These are the injuries sustained by the claimant. Hence, at the height of pain and suffering, this court is granting 60,000. Coming to the medical expenses, court had rightly granted and no interference is called for. The court, the tribunal had failed to grant any amount towards nourishment and transport. Hence, an amount of rupees 15,000 is granted considering the hospitalization. Coming to the loss of income during the later period, as this accident had taken place in the year 16,
17.
uh,
26/8/2017, my lord.
on 26/8/2017, this court is taking the income at 11,000 and for 3 months, 33,000. And legal expenses, same in the light of the law laid down in so and so, legal expenses 10,000. In the other case, it is not given, I think, in the earlier case, it is given. The claimant is entitled for an amount of rupees 2,58,000. Accordingly, appeal is partly allowed, enhancing from 1,80,000 to 2,48,000, 6%. Next.
Cell number 5. Puttaswamy C. For appellant.
For the
K. Krishna.
appellant claimant matter. It's a case of death. The trial court has taken only 6,000. The accident is of the year 2016, my lord.
How many are the
Dependents are six members. 6 members. Wife, 2 minor children and parents. The tribunal has taken 8,000.
No. The dependents are 6 in number.
Yes, madam.
Then how much has to be deducted?
1/4 has to be deducted.
Said 6 in number.
Yes, madam.
6 into 44.
2,64,000, madam.
2 lakh?
64,000.
36,000. 10,000. It comes to 21 lakhs 500, 5,000.
5,500. Yes, madam.
The agreed with the order passed in MVC number 8/2016 dated 22nd June 2018. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 50 lakhs the death of the deceased. The claimants are 6 in number. The tribunal, according to the claimant, is earning how much?
40,000 per month.
Is earning 40,000
40,000 per month.
per month, and the tribunal had taken
8,000.
8,000. It is submitted that. How much is deducted? 1/4 only.
1/4 is.
Court had deducted 1/4 and granted the compensation. Then counsel appearing for the claimant submits that. The court ought not to have taken the income at 7. How much was taken?
8,000 was taken.
8,000 ought not to have taken 8,000 as income. When committee submitted that the compensation that is awarded by the tribunal is on the lower side. Same and counsel appearing for the respondent submits that it's a so and so reasonable compensation. Further counsels on either side. This accident had taken place in the year 2016. The tribunal had taken 8,000. This court is taking 9,500. The age is?
Age is 37 years, madam.
37 years. Future prospects at 40% comes to 3,800. That is 13,300. There are 6 claimants. 1/4 has to be deducted. 1/4 is 3,325. If the same is deducted, it is his contribution to the family is 9,975 into 12 into 14.
So 15, madam.
Into
15.
15. That's what I said.
Yes, madam.
Is 70,95,500. And there are towards consortium 6 into 44, 2,64,000. Funeral expenses 36,000. In the light of the law laid down in make law also, so and so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 21,05,500. The enhanced amount shall carry 6% interest. This next.
Cell number 6.
One submission. Here in this case, Puttaswamy is no more the claimant advocate. I am on record. His name may be deleted and my name.
To file your wakalat.
I have also.
It is the registry is directed to relate in the docket order. So and so's name. Yes, next.
Cell number 6. Nagaraj HR. For
What happened
appellant.
to this is 5? Yes, 6.
L. Ashwath,
Much.
Ashwath Narayana,
I prefer appellant.
Kishore Kumar.
I was not present.
For
my lord.
respondent, I am appearing. Respondent number 2.
I was not present, my lord, on the last date of
Correct.
hearing. It was calculation has been done, my lord.
It's coming to 10,000 enhancement.
Lord,
Now legal expenses if added, it will come to another 20.
loss of immunities, there is no.
It's already granted.
No, not granted.
No, I have granted 10,000. That is what is the enhancement.
Loss of immunities, not
What is the disability?
10%. And
5%
parent suffering also 30,000 has been granted.
What did you say?
29 years, Your Lordship. Multiply 17 has been taken.
30,000 has been granted to parent suffering.
Into 12 into 17 into 5 by 100.
That is as per Lord.
As per the evidence of the doctor.
Yes.
It is coming to 91,800.
Not even in the local.
In a disability of 5%, how can there be loss of amenities more than 10,000?
Not in before the local not minimum 40,000 will be the
loss of immunity.
No, for pain and suffering for one fracture.
Granted.
That has not been.
No, this
fracture of Your Lordship, this is a fracture of 4th and 5th metacarpal.
Pain and suffering 40,000.
Yes.
Medical expenses 8,471 as per the court. Loss of earning during the laid up period 3 into 9.
4 months granted already.
By the
trial.
Let's see.
Yes.
36,900. They granted for 4 months.
Loss of earning during the treatment, the court had granted 36,000.
Yes.
Taking how much was taken as income?
9,000.
That's for 2015, Your Lordship. Correct.
4 into 9. It comes to 36,000.
Yes.
Except amenities, other heads are reasonable.
He was in the hospital for 5 days.
Yes.
5,000 is a reasonable amount towards that. Then 9,000 into 12 into 17 into 5, 91,800.
That is correct.
Loss of amenities 10,000. It can't be more than that for 5%.
In case of 20,000 would be awarded. 20,000 may be awarded.
Only fracture of metacarpal, 4th and 5th.
Yes.
Only 2 fracture, metacarpal.
Yes.
4th and 5th metacarpal, Your Lordship.
Now it's coming to 2,01,271. Please come. Agreed with orders passed in MSC number 539 of 2015 dated 4th August 2018. The claimant is before this court seeking enhancement of the compensation. We submitted that the tribunal had not granted the reasonable compensation. It is stated that when the doctor's evidence is that he is suffering with disability of 5%, the court had not considered the evidence and not granted the amenities and also the amount that is granted and the head of pain and suffering is on the lower side. Next parallel and counsel appearing for the insurance company same submitted. Having got the counsels on his side. The claimant had sustained 2 previous injuries, hence his court has sustained 1 previous injury, and this court is taking 40,000, granting 40,000 towards pain and suffering. Medical expenses, court had rightly granted, no interference is now for. Coming to the loss of income, considering the fact that this accident had taken place in the year 2015, this court had taken 9,000 as income, 4 into 9, 36,000. Then toward transport, nourishment, the trial court had rightly granted 5,000 and no interference is called for. Even under the head of loss of income due to disability, court had rightly granted 91,800. Coming to loss of amenities, considering the disability, this court is granting 10,000. In the light of so and so, 10,000. The claimant is entitled to compensation of 2,01,271. Accordingly, appeal is partly allowed, enhancing from 172,170 to 2,1,201,271. Enhanced amount 6%. Next.
Bill number 7.
Obliged.
Harisha, SP for appellant. Mrs. Sitaram Rao.
Plus, I appear for the respondent.
Yes.
Plus, this is a case of injury.
Now, as per the calculation, it is 10,21,660. Already calculation is made on the day.
Please, my lords.
Pain and suffering 1 lakh. Medical expenses 3,50,000. Food nourishment 28,000 for 28 days hospitalization. Loss of income during the later period 9,000 into 3, 27,000. Loss of future income 9,000 into 12 into 16 into 27. 4,66,560. Loss of amenities 50,000.
Please, my lords.
It's coming to 10,21,660.
Please, my lords.
Agreed with orders passed with MBC number 59702. This is MBC number 597 of 2015, dated 8 July 2016. The claimant is before this court seeking enhancement of the compensation. It's a case of the claimant that he had sustained injuries in the accident that took place on 24/2014 and claimed compensation of an amount of rupees 21,80,000. The tribunal had granted the compensation as per the table given below. Land Council submits that the tribunal had not granted just and reasonable compensation. It is submitted that when he was in the hospital for 28 days, court had granted only 18,000 towards the food, diet, nourishment, and conveyance. Then coming to the loss of income during the later period, the court ought to have taken the income at 9,000. And towards the permanent disability, when the doctor had opined that he has sustained 27% disability, court had taken only 25% disability. And towards the loss of amenities also, the amount that is granted by the tribunal is not reasonable. Insurance company council submission, the very same. This court had perused order. The tribunal had granted the compensation as per the table given below that you have read. This court had perused order passed for the tribunal under the head of pain and suffering, medical expenses. Court had rightly granted the amount coming to the food, diet, nourishment. Considering the 28 days of hospitalization, this court is granting 28,000. Then loss of income during the later period. Considering that this is an accident of 2015, this court is taking 9,000 and into 9,000 into 3, 27,000. Then coming to the disability, court ought to have taken 27% when there is an evidence of the doctor. Hence 9,000 into 12 into 16 into 27 by 100 is 4,66,560. Court below had rightly granted the amount under the head of loss of amenities. Future medical expenses are also there. Future medical expenses.
Because that has been factored into the medical expenses itself, my lords.
No. 15,000 and another 15,000 towards future medical expenses is granted. Apart from 50. So we will make it 20,000. Future medical expenses 20,000. Okay, granted future medical expenses. What is that you've written? And as far as the loss of amenities 50,000, coming to the future medical expenses, this code is granting 20,000. Altogether, the claimant is entitled for an amount of rupees 10,42,660. Accordingly, appeal is allowed, enhancing from 8,49,600 to 10,42,660. The enhanced amount shall carry 6% interest.
Cell number 8, Guru Prasad BR for appellant, A.N. Krishnaswamy.
Lords, on the last occasion, your lordship has calculated an enhancement of rupees 4,05,200. Insurance company officials have also not.
We need to find joint memo, my lord. Otherwise, we'll
Dictate
dispose.
order.
Please.
Yes, ma'am.
So in that case, consortium will go to 44,000 and funeral expenses to 36,000, legal expenses to 10,000.
Please.
Then it would come to 8,29,200. Out of what is awarded is
4,04,000.
It's a case of death.
Death, madam.
The claim petition is filed by the claimant seeking enhancement of the compensation.
And delayed days also is there, my lord. Delayed days.
That will consider. Look at that before any order. Dated MBC number 292 of 2011, dated 22nd day of November 2012. The claim petition is filed seeking compensation of an amount of rupees 12 lakh. It is a case of the claimant that the deceased has sustained injuries in the accident that taken place on 24/12/2010, and he died. The tribunal had granted the compensation as per the table given below. When counsel appearing for the claimant submits that the court had considered the income at
4,000.
4,000 at the 4,000. It is submitted that the accident had taken place in the year 2010. The court ought to have taken 5,500 as income. Multiplier and other things, no issue.
Please, no issue.
And the compensation needs to be enhanced. Then a counsel appearing for the respondent saying, this is an accident that has taken place in the year 2010. And though there is no evidence on record, this court is taking the notional income at 5,500. As he is aged about 33 years, future prospects at 40% comes to 2,200. That is 7,700. As there are how many claimants?
Only one claimant.
Huh?
One claimant.
1/4. Then how much has to be deducted?
50% has to be deducted.
And that's 50% is unmarried.
Unmarried, dependent.
Married. The 50% has to be deducted. It comes to 3,850 into 12 into 16, 7,39,200 towards loss of dependency. Consortium 44,000. Funeral expenses 36,000. In the light of the law laid down in so legal expenses 10,000. Altogether, the claimant is entitled for 8,29,000. Accordingly, appeal is partly allowed, enhancing from 4,04,000 to 8,29,000. Enhanced amount shall carry 6% interest. Yes, next.
Cell number 9, Manjunath ND.
Give that. What is the give the no delay? I'll tell her no the delay. Give the docket in this. There is no representation on behalf of both the parties. As is an appeal of 2018, this court is proceeding to decide the same on the merits of the matter. This claim petition is filed seeking enhancement of the compensation by the claimant, agreed with the orders passed in MBC number 1352 of 2016, dated 30th December 2017. The claim petition is filed seeking compensation of an amount of rupees 19 lakhs, and the tribunal had granted an amount of rupees 3,57,000. And counsel appearing for the claimant submits that considering the to previous injuries sustained by the claimant, the amount that is awarded towards pain and suffering is on the lower side. It is submitted that this accident had taken place in the year 2000, 2016. The court ought to have taken the income at 9,500. Further, under the head of loss of amenities, as per the grounds, you say, as per the grounds, because they are not there. The amount that is granted on all the heads is, on all the heads, is not a just and reasonable compensation. Next para. Having perused the material on record, the claimant had sustained previous injuries. Hence, this court is granting an amount of rupees 60,000. When it comes to medical expenses, court had rightly granted, basing on the evidence, and no interference is called for. Considering the disability of 10%, court had granted, already granted 35,000 and no enhancement is called for. Coming to the loss of earning during the later period, as this court is considering 9,500 as per the, as this an accident of 2016, as per the table, it comes to 28,500. Conveyance and transport, court had granted 10,000, considering the 15 days hospitalization, this court is granting 15,000. Coming to the loss of future income, 9,500 into 12 into 15 into 10 by 100 is 1,71,000. And in the light of the law laid down in so and so, 10,000 towards legal expenses, it comes to 4,60,500. Appeal is partly allowed, enhancing the compensation from 3,57,000 to 4,60,500. Accordingly, appeal is partly allowed, 6%. Yes, next.
Number 10. Kalyanar for appellant. KN.
For the respondent.
Claimant's appeal, case of injuries. The claimant had suffered.
Already calculation is done. It's coming to 3,52,365 against 1,86,265. Pain and suffering 40,000. Medical expenses as it is. Loss of income 9,500 into 3, 28,000. Loss of future income 9,500 into 12 into 16 into 10 by 100.
Lord, disability is 10%.
10%. As per the evidence of the doctor.
Lord, here it's a case of where, my lord, L1 vertebra.
No.
Injury.
What is the evidence of the doctor? Because
evidence, my lord, the doctor says 15% to the, my lord, whole body.
Let's see. And what
Please.
is to the, he said 15% to the whole body.
My lord, may I pass on?
No, in the judgment.
Not, in the judgment, it is referred 15% and 5% is taken.
5% is taken. 24% is the limb disability.
It is to the spinal cord.
Please.
No, yes, LM.
L1. L1 vertebra.
L1.
My lord, this disability would be a
Was a
permanent
driver.
disability. My lord, it
Or
would come
driver.
in as avocation, my lord. This disability. He can't sit for a long time. He can't lift
Then we'll
weight.
take 15%.
Please.
15% will take.
Please.
15%. If that is the evidence of the doctor, we can take.
Please.
It comes to 2,73,600. Loss of amenities 40,000 is granted. Attendant conveyance 20,000. Legal expenses 10,000. It comes to 4,53,565. How much the court had taken the disability
5%.
and income?
Income at 8,000.
8,000 rupees.
No, I think that's not that side. The agreed with the orders passed in MBC number 8241 of 2016 dated 25th December 2017. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees. How much?
Please.
How much is sought?
Please, no?
8 lakhs.
8 lakhs for the injury sustained by the claimant. Tax rate. The tribunal had granted the compensation as per the table given below. Extract the table. And granted an amount of rupees 1,86,265. Then counsel appearing for the claimants of this matter. As per the evidence of the doctor, he had sustained the injury to the, where do you get that?
My lord, page number 16, my lord, 17. 17. King page number 17, judgment page number 10.
You know, at least to the injuries, where is that wound certificate discussion? He had sustained fracture of L1 vertebra, which is in previous in nature. You're recording the submission?
No, parted matter.
Counsel.
Parted matter.
It is submitted that the court, the doctor had opined that it is 15% disability and the court had taken only 5%. He submits that the said injury is going to have an impact on the life of the claimant. And in this case, it cannot be, the court cannot take 1/3 of the disability that is stated. Next paragraph. It is submitted that even under the other heads also, the amount that is granted is not a reasonable compensation. Next paragraph. Same, the learned counsel, considering this court has perused the material on record, considering the grievous injury to the vertebra, this court is 40,000 under the head of pain and suffering. Medical expenses, court had rightly granted 41,465 and no interference is called for. Coming to the income, as this accident had taken place in the year 2016, this court is taking 9,500 as the income into 328,500. Coming to the loss of future income, the doctor had opined that it is 15% disability to the permanent disability to the whole body. Court had taken 5%. Concerning the whole body disability, the limb disability at 24%. Considering the fact that it is an injury to the vertebra and it will have an impact on his life, this court is taking 15%. 9,500 into 12 into 16 into 15 per 100 is 2,73,600. Coming to the loss of immunities, the tribunal had rightly granted 40,000 and attendance charges also rightly granted and no interference is called for. In the light of the law later, 10,000. Altogether, the claimant is entitled for an amount of rupees 4,53,565. Appeal is partly allowed, enhancing from 1,86,065 to 4,53,565. And the enhanced amount shall carry 6% interest. Yes, next.
Question number 11, Padmanabh KD Laya for appellant.
What is this parted at 12 p.m.?
That is
Huh? Yes, where is the counsel? Let's see, it's already 11:44. Calculation is done. Call it at 12 o'clock. Yes, next. After this matter, call that matter. Yes. Yes.
Case number 2, Parted matter for being spoken to serial number 1.
Lord,
In
he
case
appear for
Sideshwara.
appellate. Lord, your lordship disposed of the matter, this is a owner appeal, my lord. Pain recovery was ordered. My lord, this honorable court, my lord, directed me to deposit 50% of interest along with.
What happened to your appeal?
Yes, my lord, the appeal is partly allowed, and insurance company was directed to pay the amount recovered from the owner. Lord, I may be permitted to withdraw the amount, my lord, deposited.
How can it be? Because that anyway they will recover from you. Already you have paid, over and above they will pay.
That is the reason, my lord.
Let it be. Let it be
At
the
least,
same.
my lord, your lordship kindly observe whether.
No, the present petition is filed. The matter is listed under the caption for being spoken to, saying that the court had directed the insurance company to pay and recover from the owner. Owner has already deposited 50% of the amount. As such, he may be permitted to withdraw. The insurance company will pay the remaining amount, which is as already 50% is already paid, and ultimately the order is pay and recover. This court do not find any reasons to consider this application. Yes, next discuss. Yes.
Parted matter serial number 2. Manish Kumar B for petitioner. Indra Dhanush.
Appearing for the
Yes.
even on the previous counsel, the petitioner counsel was not present.
You appear for?
Respondent. Indra
Yes.
Dhanush. It is a transfer petition filed by the petitioner, you know.
From where to where?
From Mysore to Bangalore.
Petition is who?
The wife.
What is your objection?
My lord, I have filed the petition since she has deserted me, and thereafter, my lord, she never took care of my parents. And since I have been unemployed, deserted me right now, and I am not in a situation to.
What is your submission with regard to the transfer? Why you shouldn't be transferred?
My lord, he is unemployed. My lord, he himself has been taken care by his sister.
That's the only reason.
That is the reason why she has deserted me.
Please come. Your present petition is filed seeking transfer of MC number 865/2024, pending on the file of the First Additional Family Court, Mysore, and to transfer the same to Bangalore. The facts of the case are the marriage had taken place on 13/5/2019, and it is a case of the wife that the husband has deserted the
case of the
deserted on 22/5/2022, and thereafter he have filed MC number 865 of 2024 on 28/8/2024 seeking divorce. On 4/1/2025, the wife had appeared before the First Additional Judge Family Court in MC number 865. It is submitted that she is staying in Mysore. She is staying in Bangalore, and the distance between both the places is.
Appear before court in person on 21st, my lord, please.
Huh?
I may be permitted to appear before the court on 21st, my lord.
Why? It doesn't matter. This is ultimately whether you appear through VC or you come to the court, the same order.
Please.
Both the places is about just find out and write so and so, and it's difficult for the wife to travel to Mysore on each date of hearing. Learned counsel appearing for the respondent submits that husband submits that she's unemployed and she is staying at he's staying at Mysore, and it's difficult for him to travel. And if as she has deserted and now traveling from Mysore to Bangalore would cause a lot of prejudice, a lot of hardship to him. Considering the fact, next para, having other counsels on either side, considering the fact that the distance between Bangalore and Mysore is so and so, and the wife is residing at Bangalore, considering the inconvenience that is put forth, so and so is withdrawn and transferred to so and so.
Lord, once is that, my lord, let the visitation rights be given for me to visit my child, my lord. Since the child's birth, she has not given me the visitation rights at all, my lord.
Mr. Counsel, in a transfer petition, Can this court grant visitation rights?
Direction may be given.
You shouldn't ask that kind of unreasonable, shouldn't make that kind of unreasonable request. Yes, next. Yeah. Where is the other side?
Please.
First our matter, sale number 1, list 1,
Please, case of injury, my lord. Doctor said, my lord, 24%.
Already calculation is done in this.
Please.
It's coming to 7,820
Please.
from 4,64.
Please.
The present petition is filed, seeking enhancement of the compensation agreed by the order passed in MVC number 1283 of 2015 dated 11th July 2017. The claim petition is filed seeking compensation of an amount of rupees 15 lakh for the injuries sustained by the claimant in the accident. The tribunal, the claimant had sustained 5 injuries. In that, there are 3 fractures. The tribunal had granted the compensation as per the table given below. Then counsel applying for the claimant submits that the court had taken the income at
5,000, my lord.
5,000 and the accident had taken place in the year 2014.
14.
It is submitted that on all the heads, the compensation that is granted by the tribunal is on the lower side. Next paragraph. Same contention with regard to the insurance company. Having got so and so. Considering the injuries sustained by the claimant, this court is granting. No, with regard to the disability, how much the court had taken?
Court has 20%, my lord. Doctor said 24.
The counsel submits that towards disability court had to consider the disability at 20%, when it's evidence of the doctor that it is 24%. Next, the pain and suffering, considering the grievous injuries, this court is granting 60,000 towards medical expenses. Court had rightly granted, and no interference is called for. Towards conveyance, as he was in hospital for 10 days, this court is granting 10,000. Coming to the loss of income, this accident had taken place in the year 2014. Hence, court is taking 8,500 as notional income. 8,500 into 3, 25,500. Loss of amenities, court had not granted any amount, considering the disability of 24%. This court is granting 30,000. Coming to the future treatment, had rightly granted, no interference is called for. Loss of future, when it comes to loss of future income, and the disability, when the doctor's evidence is 24% to the whole body without any basis, court had taken 20%. This court is inclined to take 24%. 8,500 into 12 into 14 into 24 by 100. It's 3,47,720. Same legal expenses in the light of so and so, 10,000. Altogether, the claimant is entitled for 7,10,820. Accordingly, appeal is partly allowed, enhancing from 4,64,600 to 7,10,820. 6% interest. Any delay in this? It is not condoned. IA number so and so is filed to condone the delay of so and so 278 days on condition. Same thing in view of the order dated so and so, they are not entitled for interest. Yes, next.
Case number 2, serial number 3.
Yes.
Ravindranath M for appellant, petitioner Sri Terati.
Appearing for the appellant, my lords, seeking transfer from Bangalore to Shivamogga, my lords.
Bangalore to?
Shivamogga, my lords.
Distance?
310 kilometers, my lords.
310,
my lords.
Any other proceedings pending there?
No, my lords.
Children?
Yes, my lords. One girl child, my lord. 1 year, 2 months, my lords.
1 year, 2 months.
Yes, my lords.
As there is no representation on behalf of the present petition is filed, seeking transfer of MC number
MC number
7424 of 2024, pending on the file of the Third District Principal Judge Family Court at Bangalore to the Family Court at Shimoga. The learned counsel appearing for the petitioner submits that the wife is residing at Shimoga and the distance between both the places is about 310 kilometers. And in the wedlock, they're blessed with a daughter who is aged about 1 year, 2 months, and she has to take care of the girl. It is submitted that it's difficult for her to travel on each date of occasion from Shimoga to Bangalore. Shimoga to Bangalore. It is submitted that considering the inconvenience that is being caused to the wife, the MC may be transferred from Bangalore to Shimoga. Next matter. Next para. When this matter came up on 9/4/2025, as a counsel for the petitioner was present and there was no representation for the respondent, this matter was directed to be listed under the caption part heard today. Today also there is no representation on behalf of the respondent. It appears that the respondent is not interested to pursue the matter and this court is disposing of the matter on the merits of it. Next para. Having heard the counsel for the petitioner peruse the material on record, considering the fact that the distance between Shimoga and Bangalore is about more than so and so, and the wife has to take care of a girl child who is 1 year, 2 months. This court deems it appropriate to allow this petition so and so, so and so. Yes.
Detail number 4, A. Swami for appellant, Pundika Ishwara Bhatt for respondent.
Yes.
Last time.
Yes, Mr. Krishna Swami.
Last time, my lord, granted time to the opposite party as a last chance. My lord, earlier a claim petition was filed under section 163A. They withdrew that. Charge sheet is filed against the deceased. And
We'll pass over and pass orders in the afternoon. Yes, next. Next.
Detail number 5.
For the appellant.
Have you filed the translated copy?
not for him.
Why is he not filing?
Covered by the.
Every time he was telling that there is some urgency. If you don't file the translated copy, how will the court understand it?
He had no driving lessons on the date of
That
that.
I understand.
I
The
got
last time
two
also you said
Supreme
the
Court
same
judgments,
thing.
directly on point, my lord.
But I have to know, for dictating the judgment, I have to read the order.
Kindly accommodate me 2 weeks, my lord. I will file it, my lord. Please.
List after 2 weeks, delete from part third. Yes, next.
Detail number 6. Arun Govindraj.
Appearing for the respondent, my lord, I pray that the matter be passed over for merely half an hour. Seniors held up in another matter.
May I kindly request for the afternoon session in this case, my lord?
My lord, seniors come in.
What is saying?
He's requesting for a passover for half an hour. My senior would be unavailable.
Not half an hour. Passed over will come in the afternoon. Yes, next.
Detail number 7. O. Mahesh.
I appear for the appellant, my lord.
For respondent number 2, my lords.
Lord, appeal by the
Respondent number
insurance.
2, my lords. Respondent number 2, my lords.
You are on what ground?
Lord, on the ground, my lord, the liability, they were unauthorized passengers in a goods vehicle, insured goods vehicle.
Next matter.
Alternatively, my lord, it was stated that even if they were to be treated as the employee of the insured, then computation has to be made under the provisions of the WC Act, not as a third party claim. In this respect, my lord, I would like to invite your lordship attention to.
So
The
according to you, they are not entitled for compensation under the Motor Vehicles Act. They have to go before the under the Workmen Compensation Act.
Yeah. Our contention is that they are unauthorized passengers in the goods vehicle.
So that is one aspect. The other aspect, just know what you
Other
say.
aspect is not that if they were to be construed as the employee of the insured, the computation should have been done as per the provisions of the WC Act, not as a third party claim.
You're relying on what is the law on that?
Yeah. The
What is
policy,
the law?
Exhibit R1 is the policy.
No,
which
no.
say,
With regard to the submission, that it has to be under the Workmen Compensation Act, but not under the Motor Vehicles Act. What is the law on that?
that is governed by, my lord, the terms and conditions of the policy. Exhibit R1 may kindly be looked into.
Please give that.
Insurance policy. Employees policy.
Exhibit R1 policy.
They themselves, my lord, in the claim petition claim to be the employee of the insured. Exhibit R1, my lord. IMT 39 may kindly be looked into, my lord. Legal liability to person employed in connection with the operation and or maintaining and or loading and or unloading of motor vehicle or goods vehicle. In consideration of the payment of additional premium as stated schedule in so and so, agreed that notwithstanding contained in the contrary, insurer shall remain held against the legal liability under Workmen's Compensation Act and subsequent amendments.
Where are you reading?
Number 3, the insured shall keep a record of the same name of each driver, cleaner, conductor or persons employed in loading or unloading and the amount of wages, salary and other earnings paid to such employees, and shall at all times allow the insurer to inspect such record. This is the condition applied under the policy. Now I will invite your lordship attention to the claim petitions filed by them. In MEC 809 of 2010, my lord, by the cleaner, said to be the cleaner, my lord, Maxon, the claim petition may kindly be looked into, my lord. At item number 4, occupation of the person injured. If lordship got it, my lord?
1 minute.
Claim petition in MEC 809 of 2010. At column number 4,
So in
occupation
every policy, this IMT 39 will be there.
39, my lord.
1 minute, 1 minute. In every policy where it is for the employees, this IMT 39 will be there.
It's a separate contract. Additional
Then
premium,
this-
additional premium has to be paid for that.
No, no. If IMT 39 is there, then you cannot claim under the Motor Vehicles Act.
Under Motor Vehicles Act, a claim petition is maintainable under section 166. However, liability of insurer would be restricted to provisions of WC Act. That is the difference.
No, understood. Yes.
Yes. Then, my lord, IMT 39.
Please come to the order.
Yes. Well, before that, my lord, I would like to invite your lordship attention to clause 3, my lord, of the IMT 39.
Yes.
The insured shall keep a record of the name of each driver, cleaner, conductor or persons employed in loading and or unloading and the amount of wages, salary, and other earnings paid to such employee, and shall at all times allow the insurer to inspect such record. Now, my lord, claim petition, my lord, in MEC 809. The name of the claimant is my lord Maxon. In column number 4, you will kindly see occupation of the person injured, truck cleaner, name and address of the employer of the insured person, so on so, 8,000 per month. That's what he said. Then, my lord, in column number 23, 24, there you must kindly see that on 25th March 2010 at about 5:45 hours, while the petitioner as a cleaner come loader of the vehicle, which is contrary to, my lord, column 4. And moreover, you must kindly observe, my lord, the owner, my lord, appeared before the tribunal, no statement was filed. Both are case of injury. In another claim, you must kindly see of by one Umesh, claim petition may kindly be looked into, my lord. In column number 4, occupation of the person loader, name and address of the employer of the insured person left blank. Monthly income rupees 8,000 per month. Then column number 24, my lord, we say that on 25th March 2010 at about 5:45 hours, while the petitioner is traveling in the lorry bearing registration number so and so, was coming from Goa towards Malpe. Here, my lord, he said traveling. He doesn't say that he was a employee of the insured. In respect of that, my lord, I would like to invite your worship attention to the complaint filed by the, my lord, the Maxon, in respect of this accident. It is in Kannada, but I'll just read out the, my lord,
Objection.
P1, my lord, exhibit P1.
Exhibit, sir.
I'll read and translate, my lord, a very short this thing, my lord, subject to what my learned friend.
Your objections. First, let us look at what are your objections.
Objection is by way of.
My lord, my objections, my lord, amended application has been filed, where I have, my lord, denied, and especially the statement of objection, column number 6 may kindly be looked into of the insurance company. Para 6. That the above respondent submit that the petitioner was travelling at the relevant time of the accident in the insured vehicle bearing registration number KA20A 8576 as gratuitous passenger for his own benefit. The said vehicle is a goods vehicle and the respondent number 2 has no authority to carry any passengers in the said vehicle. And the owner has appeared and he had not filed any statement and not produced the wage register, my lord, as he is required to, my lord, under the Minimum Wages Act, Section 18 and Rule 29, has to produce. That he had not produced. That's why, my lord, I brought it to your lordship notice. IMT 39 says that he shall maintain the register. That he had not done so. And the exhibit P1, my lord, I'll just read to your lordship attention and translate. It is just a small paragraph. It is by Maxwell, my lord. He says, ನಾನು ಕ್ಲೀನರ್ ಅಂತ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಸದರಿ ಮಧುಕರ ಈರಪ್ಪ ಪೂಜಾರಿ ಅವರ ವೇಲ್ಕಂಡ ಮಲ್ಪೆ ಈತನ ಚಾಲಕನಾಗಿರ್ತಾನೆ. ಸದರಿ ವಾಹನದಲ್ಲಿ ಮಲ್ಪೆಯಿಂದ ಗೋವಾಕ್ಕೆ ಮೀನು ಲೋಡು ಮಾಡಿ ಬಾಡಿಗೆಗೆ ಹೋಗಿದ್ದು ನಮ್ಮ ಜೊತೆ ನಮ್ಮ ಪರಿಚಯದ ಉಮೇಶ್.
Where is the finding of the court with regard to their, it is the case of the insurance company that they are the gratuitous passengers, that issue was not at all dealt with.
Yeah, that's what, my lord. That's what, my lord, I am saying that the matter requires to be, my lord, has to go back for framing of, my lord, proper issues.
I'm appointed as amicus curiae in this case, my lord.
Appointed as amicus curiae.
Yes, my lord.
We'll remand this matter.
Yes,
please come.
My lords, one more submission, my lords. Kindly see the judgment portion, page number 14, my lords, running page. Can I read? MVC number 18 of 2010. Exhibit P7 is the hospital bill which discloses the amount has rupees 43,100.
It's not about that. They are on the fact that the insured are gratuitous passengers.
Yes.
It is their contention. You have not examined anybody to show that you are an employee. The owner has not contested the matter.
Yes, ma'am.
The agreed with the orders passed in MVC number 809 and 8010 of 2012, dated
2010, my lords. 2010.
2010.
Yes, ma'am.
Dated 28th November 2011. The claimants or the insurance companies before this court questioning the liability. It is a case of the claimant that at about 5:45 a.m.
on 25/3/2010.
On 7/5/2010 at about 8 p.m. the claimants were proceeding in a lorry from Goa towards Malpe, and when they reached Alva Kodi Unta on NH7, the driver of the said lorry drove the same in a rash and negligent manner without observing the traffic rules and regulations, and dashed against another lorry, and they have sustained injuries and they were taken to the hospital. It is a insurance company has filed its objection stating that the accident had taken place, that the owner and insurer of the opposite vehicle should have been made a party to the claim petition, and further they are the gratuitous passengers, are not entitled for any compensation. Further, the insurance policy discloses that even if they are the employees, they are entitled for compensation under the Workmen Compensation Act, but not under the Motor Vehicles Act. It is submitted that Motor Vehicles Act, the tribunal had granted compensation to the claimants, holding that the accident had taken place because of the rash and negligent driving of the driver of the lorry in which they were traveling. Next part. When counsel appearing for the insurance company submits that the court had not considered the objection that is raised by the insurance company, and no evidence is let in by the claimants to show that they are the employees, and the owner of the said vehicle has not contested the matter, and they are not liable to pay the compensation. When counsel appearing for the learned amicus curiae appearing on behalf of the claimant submits that court had rightly considered and granted compensation, as they are the employees of as they were working with the employee of the owner of the vehicle, That's better. When the insurance company had taken specific objection with regard to their liability, particularly on the ground that they are the gratuitous passengers, the court had failed to consider and give any finding in that regard. And unless and until a finding is there that whether they are the gratuitous passengers or not, the insurance cannot be made liable to pay the compensation. In that view of the matter, this court deems it appropriate to set aside the award passed in so and so and remand the matter to the court below for fresh consideration. Accordingly, the appeals are allowed and the so and so is set aside and the matter is remanded. Without further notice, the party shall appear before the court on 10th of June. The amount and deposit shall be kept transferred to the trial court and kept in fixed deposit. Yes.
Cell number 11, list number 1, pass over matter, cell number 11. Krishna Kishore.
Where is the advocate for the
claimant?
Let's look at it. Look at there is no representation on behalf of the appellant. So company is present as part heard on 15th. Yes. Agreed with the orders passed in MDC number 230 of 2015 dated 11 June 2018. The claimant is before this court seeking enhancement of the compensation. The client petition is filed seeking compensation of an amount of rupees. Seeking compensation for the injury sustained by the claimant in the accident. The tribunal had granted an amount of rupees 4,40,000 towards compensation. When this matter came up on the last occasion, this court had heard the learned counsel appearing for the insurance company, and there was no representation on behalf of the appellant. When the matter was directed to be listed today as part heard, today also there is no representation on behalf of the appellant, and this court is proceeding to pass orders on the merits of the matter. The tribunal had granted an amount of rupees 40,000 under the head of pain and suffering, considering the two grievous injuries, considering the grievous injuries sustained by the claimant. This court is granting an amount of rupees 60,000. Coming to the loss of earning during the later period, the court had granted 32,000 and no interference is called for.
Calculation was made on the
No,
previous.
loss of income during the laid up period. That's what loss of income during the laid up period is 32,000.
No?
It is loss of income during the laid up period. Court had granted 32,000.
Yes, ma'am.
Court had granted 32,000. No interference is called for. Coming to the future loss of income, as this is an accident of the year 2015, this code is taking 9,000 as income, 9,000 to 12 into 17, and as per the evidence of the doctor, disability 20%. It comes to 3,67,200. Then coming to the loss of amenities, considering the disability, this code is granting 30,000. And towards convenience, transport, and nourishment, 10,000. In the light of the law laid down in so and so, legal expenses, 10,000. Altogether, the claimant is entitled for an amount of rupees 5,04,200. Accordingly, the appeal is partly allowed, enhancing from 4,40,500 to 5,04,200. Mr. Krishna Kishore, when counsel appearing for the insurance company shall file the wakalat within 1 week.
Please.
Next.
Serial number 8. List number 2, serial number 8. For
Second
orders
respond
matter.
appeal. For appellant. And you pray for him. The senior
Permission
not feeling well.
Give that. What is this matter about?
Damage claim.
Damage to the
Damage to
vehicle.
the,
What is the order of the court?
Para
Let's see.
para 11 of the judgment, please.
Para?
Para 11 of the judgment. As per exhibit P for 146, depreciation calculated 4 lakhs. RIC value comes to 1,45,1,65 plus survey fees on 1,000 rupees. As per evidence of the PW 14, the losses sustained by the appellant is now 2,34,000. Then settled by the
Court had granted 2,34,000.
as against 4 lakh, please.
4 lakh?
4 lakh.
4 lakh.
4 lakh.
What is evidence? Now,
As per exhibit
P1 is
146,
the
please.
FIR, P2 is the copy of the statement, spot margin, PM report, copy of the charge sheet, sketch, salary certificate, copy of the ration card. Which is the bill? Exhibit P16 is the bill.
146, please, madam. Survey report.
What is that?
146, survey report. The finding at 11 of the judgment, please.
No.
Huh.
What are the exhibits which show that this is the amount incurred or to be incurred?
As per exhibit 146, please, madam.
Exhibit 140?
46, survey report. It is survey report says that 4 lakh rupees, please, madam, totally.
4 lakh?
4 lakhs. The salvage value of the RIC along with the RC book assessed by the 1,65,000 plus 1,000 survey fees minus 1,66,000. It comes to 2,34,000 as against the 4 lakhs. They the same
It
settled
should
by
be
us.
minus 1,66,000.
That is RIC value, please. RIC values, RIC value, salvage value,
Survey value.
and 1,000 rupees survey report.
Come
Fees
to
of
that, please again come to the discussion.
Para 11 judgment, please.
Read from para 11.
Further, it is case of the petitioner due to the said accident, the Toyota Qualis Maxi cab completely scrapped and was taken the Swagat Auto Works manager. The kept in garage till the vehicle is the same condition as caused by the accident. The surveyor has been examined as a PW 14. PW 14 stated that as per the dated so and so, the request made by the United India Answer Company third respondent, the inspected by the Toyota Qualis so and so vehicle and accordingly has been given the report exhibit 146. 146 survey report given by the PW 14 surveyor. In the report assessed and noted that a vehicle completely scrapped. It need not be repaired. Therefore, has been assessed the estimation total loss caused to the value of the vehicle as per the survey report 146. Insured depreciation value of the as per policy of the insurance stated 4 lakh rupees. Salvage value RIC along with the RC book assessed to the 1,65,000. Further survey report deducted excess clause of 1,000 rupees. Therefore, according to surveyor exhibit evidence of the PW 14, survey report 146 assessed estimation of the petitioner sustained loss of rupees 2,34,000, rupees 4 lakhs, 1,65,000 plus 1,000 rupees. PW4 was into the cross examination. Nothing has been contradiction revealed by the disbelieve the evidence of the PW 14. Documentary evidence of 146 therefore produced. It is proved that petitioner sustained a loss of rupees 2,34,000 as stated with survey report executed documentary evidence survey report. That we have settled the plea.
And why all these translated copies for what?
Though it is posted before the district justice. I don't know exactly.
What is the purpose of this, all the translated copies? Evidence is on record. It's a surveyor's report is there. Court had rightly granted. Please look at this file, take the court file, look at it, we'll pass orders in the afternoon.
Senior not feeling well. One week time.
No, 2
Don't know
weeks.
that matter.
2012 matter will not be adjourned. Maximum you will have it tomorrow, listed this matter as a parted. No further time will be granted at the request of non-counsel for the appellant. Next.
Cell number 9. Cell number 9.
We have filed translated copies to the court, Madam.
Yes.
No, in the objections it has not filed, it has come.
Give that.
Copy is also not served on us, my lord. Yes,
Translated copies, so why should?
Then why should, how can I argue, my lord, when my learned friend is.
When counsel submits that, they have already filed the translated copies.
Please.
Registry shall place this before the court and then the counsel shall also serve the copies on the counsel appearing for the respondent. This is matter day after tomorrow. Yes.
Cell number 10.
Respond number 3, madam.
Number 10.
No, he says that this matter is settled.
Yes, madam. The Vijay
So
Kumar is
morning
appearing.
who is saying, but I think wrongly he has given the number or what? Mr. Shastri was saying in the morning that this matter is settled.
No, my lord. Serial number 10 in the second list.
That's so. He said in the second list. See the second list.
Second list.
You were saying it is settled for 10,000.
KPSRTC Vijay Kumar is appeared for appellant, madam. Vijay Kumar.
No representation on behalf of the appellant. This is matter after vacation.
Date may be fixed.
Yes, next.
Cell number 11. Cell number 11.
Finally, a week's time is granted for complying with officer for taking necessary steps, or else the appeal shall stand dismissed.
Cell
Next.
number 12.
For appellant, madam.
Jagdish.
Case of injury filed by the owner of
But
the
he is
vehicle.
there for the respondents, which is the insurance company.
My lord,
Niranjan.
owner appeal, my lord, is a claimant is the sole respondent, my lord. R1, my lord, is not yet served, my lord. He has filed the execution petition 8/2023.
He will file if you have not if you are not doing anything from 2017. Why should we stop?
My lord, I make a submission, my lord. Notice is not yet served, my lord. I take a hand summons to party and.
Do whatever you want to do.
My-
We will not stay the proceedings,
My lord,
whichever of the year.
My lord, I make a submission, my lord. Already granted by this honorable court is stay, my lord.
Let's
But order dated, my lord.
Docket.
26th March 2018, my lord. Sorry, 20th November 2019, my lord.
Because if the steps are not taken within a week, the appeal shall stand dismissed
Madam,
without further reference to the court.
My lord, I taken 3 times,
This
my lord,
order
is
was
what it served.
passed, this order was passed on 16/11/2023.
Already taken is not yet served, my
When you
lord.
have taken?
Taken notice already taken, my lord, is not yet served, that
When is that?
written the process. Cover is written.
Or notice issued to respondent unserved cover lettered with no such a person in the address.
My lord, kindly direct the notice to execution in case I appearing for the counsel, my lord, is Suresh, my lord. Kindly direct, my lord, I will serve the notice.
When counsel for the petition is appellant is permitted to take out notice on the counsel appearing for the respondent before the executing court and file the memo to that effect by 18th of June, or else the appeal shall stand dismissed against the respondent.
My lord, earlier interment is granted, kindly assume.
If the court is not understanding an order of the Supreme Court, what we can do?
But
That is not required now.
that correct, my lord, is subsequently.
It is submitted that though the stay is granted, still the trial court is proceeding with the execution of the same. When already there is a stay by this court need not clarify if the executing court is doing something contrary to the orders of this court. There is a procedure known to law, and The appellant is at liberty to pursue the same. Yes.
Cell number 13, O Mahesh for appellant.
But I appear in MFA
Litigate
5044 of 2018. A week's time may be granted, my lord, to verify the publication. And in the connected matter, my lord, the other respondents are not yet served.
You are
They have-
supposed to file this by 7/3/2025 when this matter has come up before.
My appeal is, my lord, MFA 5044 of 2018.
That's what
Paper
I'm,
publication was allowed. And I have to verify, my lord, with the insurer whether it has been done or not. But in connected matter, my lord, MFA 9165 of 2018, there's a delay of 117 days.
we will
After
see
vacation,
later.
sir.
Yes, next.
Cell number 14, Kantrajappa MG for appellant. KN Srinivas.
No representation for the appellant. List this matter for disposal day after tomorrow. Yes.
Cell number 15,
Needful done, process is paid.
Then council submits the needful is done, post this matter after service of notice.
cell number 16. 16, Suresh K.
Appear for the appellant, 1 week maybe time granted.
Finally, a week's time, default order. Yes.
Cell number 17. 17, Ashok
I am
M.
appearing as respondents, Your Honor.
Serve the copy on him.
So it is IA number, my lord, 3 is filed by him itself.
Yes,
I know.
copy served, Your Honor. It is
Served on you?
Yes.
Hmm. Signature of deponent does not tally with that of the signature in Wakalat.
Your Honor, see, earlier when we have filed appeal before this court, he was alive, petition number 5. After filing that, when the NOC is issued, he was died. So that petition number 1 to 4.
If there are objections,
ಇಲ್ಲಿ ಗುರು ಅಂತ ಇರ್ತಾರೆ ನೋಡಿ ಸರ್ 2008
you have to submit before the registry your
Obliged.
objections to that.
Obliged, Your Honor.
Office objections shall
Your-
be
Your
complied
Honor.
within a week, less this matter after vacation.
No, Your Honor, 5828/2022, there is one more IA. 5828, that is 5660/2022. 5828, I have filed an IA to release
What
the
I have-
payment for which
The objections, what I have read is from.
that is with
MFA
regard to
5828.
5600, Your Honor.
5828 also same objection is there.
No, Your Honor,
Look at it.
because amount has been, orders has been passed to release, they also said, as a appellant also said no objection to release that one. Order has been passed, only with regard to
Show him the
apportionment.
cause list.
Signature of the deponent.
Show him the cause list.
In that also there is objection
Yes, next.
after vacation.
Call the next
Cell number
matter.
18. Let us.
And for the respondent, or the respondent.
A letter is addressed by the Additional City Civil and Session Judge, Bangalore, seeking extension of time to dispose of OS number 74340 of 2008. This court, by order dated 28/8/2004, has directed the trial court to dispose of the suit within a period of
3 months,
3 months.
date of month, 2 months, madam, from the receipt of the orders of the summit.
Date of the order. Now the letter is addressed stating that in view of the pendency and requested further time accordingly. Another 3 months time from today is granted to dispose of the matter. Yes, next.
Cell number 19.
Here for petitioner,
Rakesh
wife's
Giri.
petition for transfer from Moodbidre to Mangalore.
I have 1/25 for dispensation of production of the certified copy of the order sheet in MC number 26 of 25.
I have sort 4 weeks time to produce, man. For meantime, I
MC
can,
of which year this is?
2025, man.
IA number 1 of 2025 is filed seeking dispensation of production of the certified copy of the order sheet in MC number 26 of 2025. And he sought for a few weeks time. Accordingly, the IA is ordered and the order sheet shall be placed within 4 weeks. Then seeking transfer from where to where?
From Mudubidre to Mangalore, man.
Huh?
From Mudubidre to Mangalore. It's about 40 kilometers. Wife had filed a petition under section 12, my lord. That is pending in Mangalore. That my lords will find it.
Petition is filed seeking transfer of
Page number 11 may kindly be seen. His wife's petition. That is in Mangalore. That is pending in Mangalore.
which is that petition?
Which I am seeking for transfer is, my lord, page number 70, my lord. Page number 70 and page number 109.
Petition by withdrawing MC number 83. Allow the petition by withdrawing MC number 26. What are all these petitions?
Sorry, my lord.
You look at your prayer.
For withdrawal of MC number 83/2024 and MC number 26/25. There are 2 MCs pending before the Mudubidre court seeking for withdrawal and transfer to Mangalore court, my lord.
You will file. I'm not able to understand what is this relief you're seeking.
For transfer, my lord, from Mudubidre to Mangalore.
How many cases?
There are altogether 3 cases.
Hmm.
1 case is pending
You
before.
cannot file so all petitions in one case. How can it be?
There is no bar, my lord. In page number, para number 3, my lord, I stated.
You say allow the petition by withdrawing MC number 83. Allow the petition by withdrawing MC number 26.
Because both the parties are same, it's pending before the same court. I'm seeking for transfer before the same court. So instead of filing 2 petitions, in para number 3 may kindly be seen, my lord, my petition.
Para number?
Para number 3, my lord. Both same parties, my lord. And pending before the same court. That is why I filed 1 petition just for convenience.
I don't think, how is it called the registry?
Yes.
How they have numbered this case? Like password?
Cell number 22. Cell number 22. SV Prakash for appellant.
What happened to 20?
21 the password. 19 password.
21? He was referring to this Sripad V. Shastri.
Yes. Cell number 20, that is paper publication. Cell number 20. Cell number 20. Paper publication.
He said that is what is called.
2020. Last.
Devani Bangalore edition.
Yes, ordered.
29-4, taking draft honor before 29-4, hearing 156.
Vice.
21, Sri Padvi Shastri.
I think this is what he was saying. It is. This is matter tomorrow.
Tomorrow. Cell number 22. Cell number 22, SV Prakash.
No representation. This is matter after vacation.
For admission, cell number 23. Ishwara, agent, appellant.
Petition, my lord.
Akshay Swami.
Yes. Yes.
On previous date, my lord, the court had asked for filing affidavit as consent to the employment status of the petitioner, my lords. In filing this.
Shall file an affidavit before this court adverting to the litigation that aver in the objections filed with the counsel responsible on appropriate orders will be passed. Submits that the wife is residing in Manya along with the parents, the counsel to the respondent, working at Avis Network at Bangalore, and the present petition filed with incorrect. Yes, you want to respond on this?
Please.
The counsel for the petitioner had filed the affidavit and served the same on the counsel for the respondent. Counsel for the respondent seeks time. Let's this matter on 22nd.
Very well.
Yes, next. 23rd.
Cell number 24.
Petitioner Miller.
Rajshekar.
Transfer Miller.
Huh?
Petitioner Miller. Transfer. Bengaluru to Monday.
The
Last
counsel
occasion
for
also.
the petition is present. No representation for the respondent. Let this matter as parted tomorrow.
No, my lord. Earlier occasion also parted, my lord. This matter.
If it is parted, it would have come in parted. Give the file.
Yes, my lord. Last occasion also, respondent is not present, my lord.
Then counsel for the petition is present, no representation. It was never directed to be parted. This is matter as parted tomorrow.
Much.
Cell number 25.
For the respondent, we file a wakalat and objections to it. It's been we've received instructions from them that they don't have any objection for their application to be transferred to Bangalore urban.
My lords, what has happened is, my lords, both parties of my lords have filed a section 9 before the commercial court. So I have filed it before commercial court Bangalore rural, my lords. They have filed it before commercial court Bangalore city. The seat of arbitration is Bangalore, my lords. One of the parties falls in the Bangalore rural jurisdiction. So, my lords, today we are in just two different courts altogether. We have no objection, my lords, if the matter can be transferred to the rural court or from the city court. No problem, my lords, because we are in just adjoining courts, my lords.
No, but
That's
it
all I
may
have
be
to say.
transferred from Bangalore rural to their
I have no
application.
problem,
may
I have
be-
no problem.
Because the governing clause itself says that Bangalore courts
Give
shall
the
have
file.
exclusive.
I have filed my section 9 prior in time, my lords, before them.
No, but that's barred by jurisdiction because the governing clause itself says.
Anyhow, he is
Yeah,
not,
anyway,
he
he's not
has no
pressing. for it.
issues with that.
Yes.
The present petition is filed to withdraw commercial COMAA 315 of 2024 pending on the file of the.
No, it's 18, but their application that.
Mine is commercial 18 bar 24,
18
my
bar
lords.
2025.
There it is 315 of 24, my lords.
Two petitions are there.
One petition. Yes, I have filed a section 9, my lords. They have also filed a section 9.
They intend to withdraw their section 9 and place it before bank.
That I understand.
Yes,
I'm
ma'am.
looking at, this is a CP of 49.
Yes, my lords.
I'm looking at the prayer.
Yes.
That's what the prayer reads.
Yes, my lords. My prayer is, my lords, let the court from 90 be transferred to court hall number 11. That is what prayer was. But I don't mind either one of the courts, my lords.
No, your prayer is at page number 28.
Yes, my lords.
To withdraw 315 of 2024 pending on the file of the so and so. That's the prayer.
Yes, ma'am.
That's what I'm looking at. The present petition is filed to withdraw COMAA 315 of 2024 pending on the file of the which is this number?
CCH 90, my lords.
Huh?
CCH 90, commercial court, Bangalore City.
So and so, and session judge commercial court at Bangalore within brackets CCH 90 and be transferred to the 11th additional district and session judge commercial court Bangalore rural to enable to tag with pending proceedings in commercial AA number 18 of 2024. The Land Counsel appearing for the respondent has filed his objections, and it is stated that the COMAA 315 of 2024, which cannot be withdrawn, which number? According to
315 cannot be withdrawn, my lord.
315 of 2024 cannot be withdrawn. And at that juncture, Land Counsel appearing for the respondent submits that if commercial AA 18 of 2024 is withdrawn and transferred to the CCH 90 to be tried along with COMAA 315 of 2024, he has no objection. Accordingly, the petition is disposed of, withdrawing the pending COMAA 18 of 2024, and the same is transferred to the CCH 90 where COM AA 315 of 2024 is pending.
I'm grateful.
So
Accordingly
great.
disposed of.
So great.
Which next? Any pending applications or closed? Yes.
Number 26. Cell number 26.
No further.
By
Petitioner, my lord.
From where to where?
From Bangalore to Malur, my lord.
Malur.
Malur.
What is the distance?
Malur only, my lord.
Distance. Distance between both the
Yes,
places.
Bangalore, maybe 2 hours journey, my lord. And she is having 4 years small child.
Present
And
petition is
also,
filed.
my lord, this petitioner filed a MC petition 31 up to
Is filed seeking transfer of MC number 6601 of 2024 pending on the file of the 5th Additional Principal Judge, Family Court, Bangalore, to the Senior Division Civil Judge at Malur. It is submitted that the distance between both the places is, look at it and write, is so and so, and is difficult for the wife to travel. And in fact, some more proceedings are pending at the family court at Malur. Considering the reasons stated, there shall be stay of all further proceedings and so and so. And the petitioner shall take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 24th. If it is filed, this is matter on 25th, or else the stay granted by this court stands vacated. Next.
cell number 27. Naveen Kumar L.
Transfer petition.
Yes.
From Belgaum to Bangalore court.
Belgaum to Bangalore. Distance?
500 kilometers.
Huh?
500 kilometers.
500?
508 kilometers.
And when is the MC? MC is of which year?
MC is of 2024, Your Honor. And the case is, domestic violence case has been filed by the petition is pending before the Bangalore court,
Present
Your
petition
Honor.
is filed seeking
And the respondent is appeared before the court
answer
and is
of
also contested in the case.
MC number
In meantime, he had filed a divorce case.
14 of 2024 from the Senior Civil Judge and JMFC Ram Durga to Belgaum.
To Bangalore.
Senior Civil Judge and JMFC Ram Durga at Belgaum to the jurisdictional court and to the principal judge family court at Bangalore. It is stated that the distance between the places is 508 kilometers, and already wife had instituted.
Domestic violence case has been filed
Case
and
has been
CB is
instituted
32 of
at Bangalore.
2022, Your Honor.
Like in other case, hand summons you have to take.
Stay may begin.
Yes, next.
Same
Cell number 28.
Yes.
Teras Chandra.
Yes.
For the petition, the petition is for transfer of petition, my lord, from Chandraipatna to Bangalore, my lords.
Chandraipatna to Bangalore.
Yeah,
What
yes,
is the
my lord.
distance?
140 kilometers, my lords. 40 kilometers, my lords.
Which year is the MC?
2024, my lords.
The present petition is for seeking transfer of MC number 141/2024 from the Senior Civil Judge JMFC Chandraipatna sent to the jurisdictional family court at Bangalore. It is stated the distance is above 100 kilometers and difficult for the wife to travel. Same order, hand summons in the the earlier case.
Like
yes, next.
Same thing. Cell number
Yes.
29. Cell number 29.
Transfer petition, madam.
Santosh Kumar.
Tumkur to Ballari, madam.
Tumkur to Ballari. Distance?
300 kilometers, madam. 300 kilometers.
It is filed seeking transfer of the MC pending on the file of the family court at Tumkur to Ballari. And the distance is, you said?
300, madam.
300 kilometers. Considering so and so, stay and hand summons.
And summons
Case.
through RPD. Oh, they are not received the hand summons, my lord.
Huh?
They are not received the hand summons, my lord.
When did you take the hand summons?
No, my lord. The petitioner was informed me. Petitioner was informed me.
Did the counsel for the petition shall take out hand summons on the counsel appearing for the respondent shall file a memo to that effect by 25th. This is matter on 26th. Or else the stay granted by this court stands vacated.
Cell number
Next.
30. 30. Nagaraj D.
No representation. This is matter after vacation.
Cell number 31.
In this matter, I appear for the petitioner. Lord, wife seeking transfer of husband's petition from Lord of the KGF Kolar to the Lord of the Paugada, Lord, 200 kilometer distance.
KGF Kolar to
Lord of the Paugada, Tumkur district. Lord's,
Distances?
distance is not nearly about 200 kilometer. She has to change not 3 buses to not go to the
Which
KG.
year is the MC?
Not the MC is not the 2023 models. Both the MCs not. Husband filed in his place, not the wife filed in her.
That case you have to place before the court the proceeding sheet. What is the stage of the MC which you are seeking?
Not both not I have produced.
Where
Both
is
the
that?
MC order sheets I have produced for the not of the.
So, no, please show to the court which is the MC you are seeking transfer and what is the stage of the proceedings.
My lords, the MC number 83 of 2023, my lord, which is it is husband's petition pending on the file of the senior civil judge principal.
What is the present stage there?
Not the presence is not the cross examination of PW1. Not they take not the that is
That can't be
page
done
number
now.
Page number 27.
Once the evidence has started.
I will come to that. Lords. Page number 27. Lords, in the wife's case also, lords, I have produced the order sheet. That also, lords, it is in the stage of cross examination. Fact is this, lords. Not the petitioner's father is not the acute diabetic patient. Not he lost his leg not due to gangrene and all.
When was it?
Not that petition itself, not may I take notice that. Not that is page number 68. Not for a moment. Not para number 11. Page number 68. Para number 11.
So that is at the,
it is in her petition. The fact is this: not she has to not to go to the not the KGF. She has to change 3 buses. Not no male member is to not the accompany
I
her.
understand that, Mr. Counsel. The difficulty is, what were you doing from 23 to 25? This application could have been
even otherwise
before.
also not a husband is appearing in not the Pagoda court.
No, you have wasted the court's time for 2 years, is it not?
That
If
is-
had this application filed at an earlier stage,
that
if
is-
both the matters are heard, no, as a matter of policy, this court is not transferring any matter where the evidence has already commenced.
Not in both the cases, and in fact, not the husband is appearing in the Pagoda court, not in the MC number models which has been filed by the not of the wife. That is no impediment for him to not go and appear in not the.
As well, no impediment for you to file this petition in 2023. Take
Whenever-
notice. we
Lord,
will
may,
see.
may I request not, since not the evidence, not it is very difficult not the cross examination because not allegation against her is not she is mentally ill and not taking advantage of that not the not her he is not
What
the.
was, no, the only factor which you are putting forth is her husband, her father's, because
Yes,
of the gangrene, the,
yes.
the leg is
And
removed.
nobody is to
That
accompany.
is in the year 2023.
Correct, Lord.
From
That is-
2023
see, Lord,
to
she has
2025,
engaged
you
the.
traveled.
That is true, Lord. He can't, not the problem is this. Not that advocate, not who is appearing in the not of the KGF court. He could not able to cross examine because not the lack of not of the communication and also not of the instruction. That is why not of this she come up with this petition. At least not anyhow not of the husband is appearing in the not of the.
That can't be a ground for transfer, Mr.
Not
Counsel.
even otherwise also not 3 buses she has to change and not of the go there. That is
I
the
already said, 2 years what she was doing. Notice
And
to
not, may I request
respondents
not
and summons.
for a not short, not the kindly stay may be granted for a shorter period. Meantime, not I will discuss him with the not of the advocates so that not of the.
Vacation is ensuing, vacation
Alla,
is
adike one
coming.
thing,
When is
anyhow-
this matter going to be listed?
No,
Tell
my
the
lords,
court.
kindly see not the entire order sheet in both the cases. I have,
Coming, tell the court, when is it coming? Matter, when is it coming?
Lord, last week, not it has come up before the court. Not as they
You
taken
tell
as
the court the date will pass over. Yes.
which not of the husband's petition.
When
date,
the
not-
matter is, no, when your matter is coming up, the transfer, from which court you are seeking the transfer,
Yes,
there when the matter is coming up.
Not that I have produced, not that order sheet I have produced. That is page number, not of the 60, not of 62, my lords.
Tell, when is
That
the
is
date?
not 1-3, my lords, 11-3 it was there, not 1-3, 11-3, sorry. Lord.
So, sir, well, from 11/3 it might have been adjourned to
11/3,
some
ma'am.
other day.
Yes, ma'am.
Please find out what it is. Let's just matter tomorrow. Next.
Till number 32. Vishwanatha MS.
Transfer petition, my lord.
Yes.
Mangalore to Bangalore, my lord. 400.
Bangalore to?
Mangalore to Bangalore, my lord. 400
Bangalore to
kilometers.
Bangalore.
Bangalore.
Which year is the MC?
2025, my lord.
20?
25.
Distance?
Distance more than 400 kilometers, my lord.
Say, seeking transfer, the petition filed by the husband, pending on the file of the family court Mangalore to Bangalore, it is submitted that the distance is about more than 400 kilometers, considering the submission of the so-and-so and the inconvenience, stay of all further proceedings. In this case, the memo shall be filed before this court by 1st July hand summons, and if the memo is filed on first, list this matter on second, or else the stay granted with this court's transvacated. Next.
Cell number 33.
Wife's petition for transfer from Bangalore to Mysore, 130 kilometers, my lords. MC is of the year 2024. Evidences has not been started, my lords.
Where evidence started.
No, not started. It has not been started.
Where is the case sheet?
Lords,
That
case, the order sheet has it has page number 50, my lords. The next date of hearing plus page number 56. It was posted for orders on IA number 3. Thereafter, I filed wakalat, my lords. NOC wakalat. Page 56. We have filed our objections and thereafter nothing has happened.
The present petition is concerning transfer of the petition filed by the transfer of MC filed by the husband from
Bangalore to Mysore,
Bangalore to Mysore, and it stated the distance is so and so.
130 kilometers, my lords. Lords, the hand
This
summons.
case also like the earlier case, hand summons.
July, is it, my lords? The hand summons should be served in the before 1st of July, right? Please, my lords.
Yes.
Cell number 34. O Mahesh for appellant.
Admit post for final hearing.
Cell number
PCR
35.
to be called. Yes.
35.
I appeal for the appellant in this case.
Both are your appeals.
Both, yes.
On what ground you are before the court?
25 days delay is there in filing the complaint. And
I think there is no delay in this now.
yes, husband and wife. Both of them are served, they are unrepresented. Both of them are served. R1 is the
No, you are on what ground? I'm asking.
delay of 25 days in filing the complaint and also on quantum.
On quantum.
But substantial records are there. He's not in town for last 1 week.
Admit post for final hearing.
Cell number
Yes, next.
36.
My lord, on the quantum and contributory negligence, my lord, record may be.
And for the respondent. Admit post for final hearing.
Cell number 37. 37
morning
adjourned.
somebody made a mention.
37 adjourned. Cell number 38. Ashok and Patil.
38, I appear for the appellant.
Admit post for final
As
hearing.
I am, my lords, filing a memo seeking, my lords, to withdraw the appeal.
You want to withdraw the appeal?
Yes, my lords.
A memo is filed by the counsel for the insurance company seeking to withdraw the appeal. Memo is taken on record and appeal is dismissed as withdrawn. Amount and deposit shall be forthwith transferred to the trial court.
Please.
Yes, next.
39. Sarita Kulkarni.
Admit post for final hearing.
Case of injury, my lord, he is there. I'm ready with the
I
matter.
will not hear these matters. There are so many, there are other final hearings which are waiting. Case 40.
Cell number 40.
Admit, this also. Admit post for final hearing.
Cell number 41 adjourned. Cell number 42.
Okay, for the appellant. Plaintiff's second appeal, suit for partition. Suit was 42.
Yes.
Suit for partition. Suit was decreed in part, my lords, granting 1/4 share to the plaintiff. An appeal was filed by the plaintiff. That appeal came to be allowed in part, granting half share against the very same, my lords, decree of the trial court. Another appeal is filed by the defendant after disposal of this appeal, which is filed by the plaintiff. And that appeal is entertained and the judgment of the trial court, my lords, is set aside.
No. Please give the, when is the suit, when is the preliminary decree passed?
My lords, preliminary decree, my lords, has been passed. Your lordships will get it at,
Please give the date.
please. My lords, 6/3/2019.
6/3/2019.
Please.
That is OS number.
OS number, my lords, 6/27 of 2014.
Against that you preferred
RA number 8 of 2022.
8 of
2022. This was disposed of on.
You have preferred an appeal after 2 years.
Please, on account of Corona, my lords, the entire that period was
It was
excluded.
decreed when?
My lords, this was decreed on 7/12/2022.
7/12?
2022.
When did the defendant file the?
26.
How many are the defendants?
Only one defendant,
When did
brother
he
and
file?
sister. 26/9/2023.
Has she contested that suit or not?
Yes,
Appeal.
he has contested the appeal. He has suffered a decree.
Appeal is filed.
Appeal is filed. That appeal, my lords, has
To find a condoned delay petition.
application is filed, but delay is not even condoned. Without condonation of delay, appeal was allowed.
I've seen other matters also, what's happening? Without considering the IA for condonation of delay, how can they pass orders on the appeal?
In fact, my lords, on the basis of merger principle, this appeal itself would not have been maintainable because there is no decree of the trial
Please
court.
come to, what is the discussion on this?
There is no discussion at all, my lords. Directly, the learned judge, in fact, in my objections, I have,
So how much delay the appeal is filed?
my lords, 820 days.
1,800
20 days.
At least do you find any reasons in the order for the
There
delay?
is no delay. There is no reasons assigned for delay.
Let's
Kindly
see.
see, my lords, the order is at page 10. Directly, the learned judge goes to the points for consideration. That's at page 15. Whether defendant proves that chance is to be definitely required.
But the IA for the delay petition is not heard.
I have produced, my lords, the entire order sheet of the trial of the that is at
The present, the appeal is filed. Agreed with the orders passed in RA number 63 of 2023 dated 4 January 2025, whereby the trial court, whereby the appellate court has allowed the appeal by imposing why with the cost must be for the delay.
Not for the delay. He does not, my lords, lead the evidence. Then the
Imposing costs of rupees 8,000 payable to the plaintiff in the trial court on first step.
not the plaintiff, by the defendant.
So that's what is written in that. If you look at page 21,
In fact, even that portion,
it's payable to the plaintiff.
payable to the plaintiff.
Payable to
Sorry,
the plaintiff in the trial court on first appearance. And consequently, the judgment and decree passed in Boyce number 627 of 2014, dated 6/2019, is set aside, and the matter is remanded to the trial court for fresh consideration. Learned counsel appearing for the appellant, appellant plaintiff submits that the suit was decreed and a preliminary decree was passed on 6/3/2019, whereby the parties were granted
1/4 share.
1/4 share.
In item number 2 to 4 of the.
Item number 2 to 4 of the scheduled properties. Aggrieved thereby, the plaintiff had filed RA number 8 of 2022, which was contested by the defendant, and the said appeal was allowed on 7/12/2022, whereby the parties were granted
1/4 share, half share, modified.
Granted half share. It is submitted that, having contested the appeal, the defendant on 26/9/2023 had filed an appeal, and the appellate and an IA was filed to condone the delay of 1,820 days. Then counsel submits that without condoning the delay of 1,820 days, and without giving any finding on how a defendant who had contested the matter, having invited a judgment and decree, when the same was staring at them, how another appeal can be filed, and how the court had entertained, there is no reasons or the said reasons are not forthcoming from the order. He submits that the order of remand is bad. Next paragraph. Having heard the learned counsel, the petitioner peruse the material on record. Admittedly, even as per the proceeding sheet that is placed before the court, the delay, what happened to the delay of 1,820 days, the entire order sheet is silent on that. And how the court had entertained an appeal, again filed by a defendant who had contested RA number 8 of 2022. In that, and it was not questioned.
That was not questioned.
And that order
That
in
can be
RA
questioned only
number
before this.
8 of 2022 is also not questioned by the defendant. In that view of the matter,
Can also place a judgment of the apex court on that, on the concept of merger. I can also place the.
On that view of the matter, there should be stay of all further proceedings in OS number 627 of 2014 till the next date of hearing. Counsel for the petition shall file shall serve the notice on the respondent, on the advocate appearing hand summons trial court by 16th of July, and if the same is list the matter on 17th, or else till the next day remove that, or else a stay granted by this court stands vacated.
Very well.
Yes, next.
For final hearing matter, CL number 43, AM Venkateshwar appellant,
Yes.
Spurti Hegde,
Insurers appeal, my lord. On liability issue, my lordship.
On the ground?
There are unauthorized passage in a goods vehicle, my lord.
Yes. Please come to the finding. Judgment is in Kannada.
I have filed translated copies before this
Where
court,
is
my lord.
that?
translated copy. Was after reading, sir.
Yes. You filed the translated, yes. Read the judgment. It is arising on under the Employees Compensation, Workmen Compensation Act.
Please, my lord. That is starts from page number 25, my lord. Please.
Not employees.
The FIR may kindly be looked into, my lordship.
What is the evidence to show that you're working with him, with the owner of the vehicle as a Hamali?
Your Lordship, actually, my senior held up in other court, my Lordship.
Pass over.
Kindly pass. Lordship.
It's matter. In one transfer petition, they can seek for 2 prayers. But still, they need to file 2 different petitions. File two petitions. We'll restrict this in respect of one case.
At least one petition may be allowed. I'll file.
The present petition is filed seeking transfer of MC number 83 of 2024 and MC number 26 of 2025 pending before the senior civil JMSC Mudabitri DK and to transfer the same to the principal judge family court Bangalore. The petitioner cannot file two transfer of two cases in one petition. When counsel for the petitioner submits this petition in respect of MC number 83 of 2024, and he will carry out the necessary amendment to the corrections to the cause title and to the petition, and will file a fresh petition within 1 week from today. And in respect of MC number 26, he will file another petition. Coming to the present petition, MC number 83 of 2024 is filed by the husband on the file of the senior civil judge and JMFC Mudabitri, and the wife is staying at Mangalore. The distance between both the places is
40 kilometers. 40 kilometers.
40 kilometers. And any children?
Yes, son is studying in Mangalore.
And the son is studying at Mangalore. Considering the same, it shall be stay of all further proceedings in MC number 83 of 2024. Same hand summons by 7th. Hand summons 8th. It shall be listed or else.
I humbly request this month one date.
Huh?
This month one date. I'll serve hands. This month one date may kindly be given.
July. What is your difficulty? Stay is granted.
Oh, because.
Huh?
Okay. At least June.
So the hand summons by this week itself.
At least June first week or so.
Because there are so many matters granted in June, you are getting stay.
Yes, 7.
7, 7, 8, 7.
Because the next court has to can't take all the matters in one day. Yes, next.
Cell number 44.
Yes.
Cell number 44.
Ashok and Patil.
Patil.
Yes.
Sir, appellant.
You are on.
I appear for respond counsel.
My appeal is on quantum. There is,
You are there also on enhancement.
Yes.
He's on an announcement.
So we will see that.
I have filed the announcement.
Straight away come to case of death or injury.
Injury.
It's a case of injury, my lords. My ground is that, my lords, that there was no driving license and endorsement that is covered by Mukund Devangan. So his, my lords, appeal
Now
needs
coming
to
to
be.
the enhancement. Come to the
Yes.
table. Where is it? So coming to pain and suffering, what are the injuries?
My lord, amputation of below knee right leg, my lord. Amputation of below knee right leg was 10 years boy. 10 years boy, my lord.
Disability is?
Disability, my lord, 75% is doctors stated that, my lord. The
No.
criminal below 25%.
If that order of Justice Sanjay Gowda,
Yes, my lord.
that you have questioned it in the Supreme
Yes,
Court,
ma'am. That is, my
we'll
lord.
defer this.
Please.
Does this matter?
My lord,
No, what happens is, if that order is upheld, you will have the good benefit of, you'll get the considerable enhancement. Because as of now, I'm not following that order, and they say that
my
it
lord,
is.
this bench already passed an award, my lord, minimum wages act, my lord. Taken the minimum wages, my lord.
Do that. That's what I'm saying. That
Already
is also
said-
question.
Not this, my lords.
Already-
This is not, my lords. Your lordship's order is not taken to Supreme Court. There are bunch of
No, Master Ayush case you were saying the other day.
Yes, my lords. It
This
is.
court has applied Master Ayush case.
Yes, yes.
That you have questioned in the Supreme Court. That's
Yes,
what
my
he
lords.
said.
It is, my lords. In the.
Master Ice and Mallikarjun
all-
already referred this judgment, my lord. Already referred this judgment.
They have questioned the order passed by this court in the apex court.
Yes,
That's
please.
coming.
Please.
So let's defer this matter.
Please.
This matter in the month of July. It is submitted that similar matters are pending before the apex court. Yes, next.
Cell number 45. Sir, oh Mahesh sir, please mute your.
Yes.
Cell number 45.
Yes, Mr. Gopal.
My lord, this case appear for the appellant, my lord. My lord, in the trial court, this case.
You appear for the appellant.
I appear for appellant, my lord. From 3-4 occasions, respondent counsel is not appearing, my lord. Kindly.
Come to the court.
Yes, my lord. Kindly have it. Yes, please, much obliged.
No representation for the respondent. Yes, 46.
Cell number 46.
Insurance company appeal on the ground.
Shivane
Driver is not having a driving license. Chassis was filed under section 3-181. Owner has appeared, he has not produced the driving license.
You are the claimant.
Please, my lord, it's
The
owner of the vehicle, offending
You are the
vehicle.
owner of the
Please, my
vehicle.
lord.
Therefore, the pay and recovery order has to be passed.
That's the only option.
The appeal is filed with the insurance company questioning the liability. It is a case of the insurance, the appeal is filed, agreed with the orders passed in MDC number 738 of 2012, dated 24th August 2015. The insurance company is before this court questioning the liability. It's a case of the insurance company that the driver of the offending vehicle is not having a valid driving license. As such, the insurance company is not liable to pay the compensation. It is also submitted that the the driver is charge sheeted under
3. 3-1 read with 181 of the motor.
under rule 3-1 read with
181.
181 of the Motor Vehicles Act. The tribunal, where is the finding of the tribunal?
Please.
Paragraph 19 minutes.
The court had held that since the insurance company had failed to prove the violation of the policy conditions, being insurer of the offending vehicle, bound to indemnify the owner of the offending vehicle. As the court has held that they are jointly and severally liable to pay the compensation. Then counsel appearing for the insurance company. Mute him. Then counsel appearing for the insurance company submits that when the charge sheet itself is filed and when the charge sheet is considered by the court for fixing the liability on the insurance company, part of it cannot be ignored. When the charge sheet itself shows that the driver of the offending vehicle was not having a valid driving license, in the light of the law laid down in Swaransingh's case, the principles of pay and recover will apply. Land counsel appearing for the respondent submits to the court at rightly considered and passed orders, and no interference is possible. Next para, concerning the charge sheet that is filed, where the charge sheet is filed under section 3-1 read with section so and so of the Motor Vehicles Act. And as that charge sheet is already considered to for the purpose of determining the rash and negligent driving of the driver of the offending vehicle, this court is of the view that in the light of the law laid down in Swaransingh's case, the principle of pay and recover will apply, and accordingly, the appeal of the insurance company is partly allowed, and the insurance company shall pay the amount and record the same from the owner of the vehicle. The amount in deposit shall be forthwith transferred to the trial court.
Cell number 47, the deep B. The deep B for appellant.
Yes, Pradeep.
Appellant in this case. This case may not challenging the negligence as well as quantum of compensation. The rider of the motorcycle who was injured was consuming alcohol and while riding the vehicle.
Rider of the
Two-wheeler motorcycle dashed against the car which was coming opposite direction.
You insure the car.
Insure of car. The police after thorough investigation have filed a charge sheet against the rider of the motorcycle. Injured himself, self negligence. My lord, as per the medical records, my lord, he was consumed alcohol. It has been in the discharge summary. It is forthcoming, and moreover, my lord, PW2 during the course of cross-examination admitted that
by the court. Let us see.
Please.
That aspect.
That aspect, please. Para 10, my lord.
Please read.
I have discussed above, as per the version of the PW1 petitioner, the accident occurred due to the rash and negligent act of the driver of the car bearing number so and so. The accident took place. On the other hand, as per the version of the RW1 accident caused entirely due to the rash and negligent of the rider of the motorcycle, that is the petitioner himself. The accident took place on perusal of the police
case of injury.
Injury case. Consumption of alcohol, my lord, PW2 doctor who admits in the cross-examination, it is true that.
We'll read further.
Please. On perusal of the police records and the charge sheet, which is clearly revealed that the rash and negligent of the rider of the motorcycle, that is the petitioner, the accident took place. It is to be noted that the support of his evidence, the petitioner has not chosen to examine any eyewitnesses to prove the accident was occurred due to the rash and negligent act of the driver of the aforesaid car. It is pertinent to the note that both the petitioner and respondent number 2 have
taken contributory negligence, 20% on the
80% against the insurer of the car, 20% against the injured.
No discussion about the charge sheet that is filed against him.
It has discussed, my lord, para 10, second line, from the bottom. On perusal of the police records.
And where is the discussion about the evidence of the doctor that he consumed alcohol?
PW2, my lord.
You get it in the order itself?
No, my lord.
Take that.
Second line. And I put a flag that, my lord, and the discharge summary that is. Mandya Medical Institution discharge summary, that's also forthcoming. He was consumed alcohol.
Please come. The present appeal is fine. Agreed with orders passed by the insurance company. Agreed with the orders passed in MBC number. Agreed with the award passed in MBC number 1470 of 2014, dated 2nd January 2016. It's a case of the claimant that on 11/5/2014 at about 4:30 p.m., he was proceeding in his Bajaj Discovery motorcycle slowly and cautiously on the left side of the Madur Malavalli road. When he reached near Goravanahalli gate, at that time, the Maruti car, being driven by its driver in a rash and negligent manner, and high speed, came from opposite direction and dashed against the claimant and caused the accident. And he fell due to the said impact. He fell down and sustained injuries. When it's come to the with regard to the accident, the court gives a finding that as per the evidence, as per the police records, a charge sheet is filed against the driver against the claimant himself. But however, the court observes that neither of the parties have placed before the court the relevant material and fixes the contributory negligence at 20% on the rider of the motorcycle and the 80% on the driver of the opposite car, and accordingly granted compensation of an amount of rupees 3,40,560. Next part. Land Council, the Land Council appearing for the insurance company submits that as per the evidence, on record clearly shows that because of the negligence, because of the negligence of the claimant himself, the accident had taken place and the charge sheet is filed against the claimant. Even the doctor's evidence, that is PW2 evidence, PW2?
PW2, doctor.
Evidence shows that he has consumed alcohol at the time of accident. All these things clearly shows that there was no the negligence is on the part of the claimant, and for his own negligence, he cannot claim compensation when he filed an application under section 166 of the Motor Vehicles Act. Though notice is served and on the respondents, no wakalat is filed. Having heard the Land Council for the petitioner, the appellant peruse the entire material on record. This court, the police records are placed before the court, and the police records reveal that the charge sheet is filed against the claimant himself. The court gives a finding that both the parties have not filed the document in support of the negligence of the driver. When an application is filed under 166, the burden lies on the claimant to prove that there is negligence on the part of the opposite vehicle. When the police records are against him, all the more responsibility lies on him. But the said responsibility was not discharged by him. And whatever material on record, it points out at the negligence on the part of the claimant. In that view of the matter, he can't seek compensation. He's not entitled for any compensation in an application that's filed under 166 of the Motor Vehicles Act, and the order of the award of the tribunal granting compensation needs to be set aside, and accordingly the appeal of the insurance company is allowed, and the insurance company is at liberty to withdraw the amount deposited.
Serial number
Next.
48, Gurudev Prasad KT. 48. Gurudev
Who is R2?
Appear for the
Pradeep, who is R2? Huh?
Owner of the car.
Notice to R2 is dispensed with by this court by the order dated 23/11/2023. Then a notice to R1, though notice is served, none appears. Yes, next.
Appear for the second respondent, my lord.
Which case?
Cell number 48.
Paitare.
Where is Mr. Gurudev Prasad? Pass over.
Cell number 49. Cell number 49.
You are on what ground?
Only on
I am for
liability, my
respondent
lord. The accident occurred, my lord. I am the insurer of the goods auto. And he dashed against my lord, another motorcyclist, my lord, and the rider got injured. The amount is, my lord, though the amount is very less, my lord, I have questioned this on liability, my lord, to show that the driver of the goods auto did not have the license to drive the goods auto, and that he had only license to drive a two-wheeler is established by the evidence of the insurance official, and he has produced exhibit R2, my lord, the driving license. And the tribunal comes to the conclusion, I have not laid evidence. This is erroneous, my lord.
You appear for whom?
Claimant.
And owner of the vehicle is served?
Yes, my lord, served and represented. But para 18, my lord, is the finding on now.
Yes.
So far as the liability is concerned, the petitioner has contended first respondent is the policy holder, second respondent is the insurer, and third respondent is the owner of the offending vehicle. Though contention was taken that the driver of the goods auto was not having valid license as on the date of the accident, it's not proved by respondent number 2. RW1 has produced the policy as exhibit R1. Hence, as on the date of the accident, policy was in existence.
So please come to the exhibits what are marked.
Exhibit R2 is the driving license, my lord, which is not discussed at all, my lord. R2. Clause number 7, my lord. Can I pass on, my lord? I have the certified copy. My lord, clause number 7, my lord. Class of vehicle, my lord. Motorcycle with care. And this was valid for 20 years.
And what is the vehicle he was driving?
Goods auto, my lord.
Pay and recover. The agreed with the order passed, award passed in MEC number 96 of 2011, dated 9th August 2016. The company is before this court on the ground of liability. Then counsel appearing for the insurance company submits that the driver of the offending vehicle is not having a valid driving license to drive the goods vehicle, that is the auto. He is having a license to drive the two-wheeler. In support of their case, they marked exhibit R2, but the tribunal had fixed the liability on the insurance company, holding that the insurance company has failed to adduce the evidence. And counsel has drawn the attention of the court to para number 18 of the order and also to exhibit R2, and submits that the insurance company is not liable to pay the compensation. Next parallel, counsel appearing for the, what about the owner? Sir, the counsel appearing for the insurance company, the claimant submits that whether he is having a driving license or not, the claimant being a third party to the insurance policy is entitled for compensation. Next parallel, though notice is served on respondent number 2 and 3, no wakalat is filed on their behalf. Next parallel, having heard the counsels on either side, there is a material record. The exhibit R2 discloses that he is having a driving license to drive a two-wheeler, and the vehicle is, the offending vehicle is a goods vehicle, which is which is an auto. And in the light of the certain law, in the light of the law laid down in so and so, as the driver is not having the driving license, there's still the insurance company, the pay and recover will apply, and the insurance company shall pay the money and recover the same from the owner of the vehicle. The tribunal, without appreciating exhibit R2, had held the insurance company liable to pay the compensation. In that view of the matter, the appeal is allowed, and the insurance company shall pay and record the same from the owner. Amount in deposit shall be forthwith transferred. Yes, next.
Till number 50. Shivareddy KN.
Regarding liability challenged by the owner of the vehicle, owner come driver of the
Ramesh Kumar
vehicle.
RV.
The reason for liability foisted by the tribunal on the owner of the vehicle is he did not have any DL minor, but fortunately he has he had a LL minor.
Password. Yes, 51.
Number 51.
Admit post for final hearing. It's already in final hearing. This is matter after vacation. Is 52.
52. Pulkeshi Reddy.
It's also after vacation.
Cell number 53.
As we forfeiting this case, my lord.
After vacation.
Cell number 54.
Notice to R4 में करेंगे.
51 है.
R4 में.
Take that.
Cell number 51 madam.
54 alla, 53.
53.
53 point.
And 53.1. A memo is filed seeking dispensation of notice to R4. Same is taken on record and dispensed with the risk of appellant. Yes, next.
Cell number 54. Chandrasekhar C.
For appellant, a week's time may wait. I have informed the other
This
side.
matter after vacation.
55.
Interim order may be extended.
Interim order if any.
Oblige.
Yes, 57.
56, 55, 56 urgent, 57.
Also
Petitioner,
after.
my lord. Lord, my lord, in this case, the witnesses, my lord, the court notice had gone to the two witnesses. Lord, the witnesses are not traceable. But the Evidence Act says in case you're not traceable, the testator's signature may be verified, my lord. But may be permitted to file an application in that effect, my lord. And it may be had next week, my lord, just for allowing that application. May no respondents.
This is matter next week.
On
at the
21st, my lord, request for 21st, please. Much obliged.
Yes. All the pastors at 2:30. Yes.
Court officer, serial number 51 ಏನಾಯ್ತು ಮೇಡಮ್? Hello?
51 after vacation, sir.
51 after vacation.
Yes. 30. ನೀವು represent ಆಗಿಲ್ಲ after vacation. No representation.
Madam, list 2 ಅಲ್ಲಿ seal number 43. 3. ಪಾಸ್ವರ್ಡ್ ಆಗಿತ್ತು ಮೇಡಮ್.
What of sir? What of sir?
ಓ ಮಹೇಶ್ ಸರ್.
ಇದು ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್
ಅಲ್ಲ ಸರ್, ಈ ಮನೇಲಿ ಏನೇನೋ ಪಕ್ಷಿಗಳನ್ನೆಲ್ಲ ಸಾಕೊಂಡಿದ್ದೀರಾ, ಅದೆಲ್ಲ ಸೌಂಡ್ ಮಾಡುತ್ತೆ ಡಿಕ್ಟೇಷನ್ ಆಗೋವಾಗ.
ಮೇಡಮ್ ಪಕ್ಕದಲ್ಲಿ ಮರ ಇದೆ, ಮರದಲ್ಲಿ ಹಕ್ಕಿಗಳಿದಾವೆ, ಏನ್ ಮಾಡೋದು, ಎಲ್ಲ ಕಿಟಕಿ ಹಾಕಿದೀನಿ ಆದ್ರೂ ಬರುತ್ತೆ.
ಅದು ಏನ್ ಗೊತ್ತಾ, ಡಿಕ್ಟೇಷನ್ ಆಗೋವಾಗ ಸೌಂಡ್ ಆಗುತ್ತಲ್ಲ, ಮೇಡಮ್ಗೆ ಅದು ಡಿಸ್ಟರ್ಬ್ ಆಗುತ್ತೆ.
ಇಲ್ಲ ನಾನು ಅದನ್ನ ಯಾವಾಗ್ಲೂ ಆಫ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಅಷ್ಟೇ ನಾನ್
ಹೇಳಿ
ಮಾತಾಡ್ಬೇಕು ಮಾತ್ರ ಮಾಡ್ತೀನಿ.
ಹೇಳಿ ಸರ್.
ಲಿಸ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್ 34 ಮೇಡಮ್.
34 ಆಫ್ಟರ್ ಅಡ್ಮಿಟ್ ಟು ಫೈನಲ್ ಹಿಯರಿಂಗು ಸರ್.
ಥ್ಯಾಂಕ್ ಯು. ಅಲ್ಲ ನಿಮ್ಗೆ ಅದು ಹಕ್ಕಿಗಳ್ದು ಅಷ್ಟು ಜೋರ ಕೇಳುತ್ತೆ ಮೇಡಮ್?
ಹ್ಞೂ ಸರ್, ಇದು ಸ್ಪೀಕರ್ ಆ ಥರ ಇದೆ. ಎಲ್ಲ ತುಂಬಾ ಇದು ಫ್ರೀಕ್ವೆನ್ಸಿ ಚೆನ್ನಾಗಿರೋದು ಹಾಕ್ತಿದ್ದಾರೆ.
ಇಲ್ಲ, ನಾನು ನಮ್ಮ ಕಂಪ್ಯೂಟರ್ ಇವನ್ ಕಳ್ಸ್ಬಿಟ್ಟು ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ಇದನ್ನ ಸೌಂಡ್ ನ ಡಿಸೇಬಲ್ ಮಾಡಿದ್ದಾರೆ.
ಹೋಗ್ಲಿ ಒಂಚೂರು ನಿಮ್ ರೂಮ್ ನ ಸೌಂಡ್ ಪ್ರೂಫ್ ಮಾಡ್ಕೊಂಬಿಡಿ. ಇಲ್ಲಾಂದ್ರೆ ನೀವು ಟ್ರೂ ವಿಸಿನೇ ಅಪಿಯರ್ ಆಗ್ತಾ ಇರೋದ್ರಿಂದ ನಾಟ್ ಫಾರ್ ಅವರ್ ಕೋರ್ಟ್ ಸರ್, ಇಟ್ ವಿಲ್ ಬಿ ಡಿಸ್ಟರ್ಬಿಂಗ್ ಟು ಅದರ್ ಕೋರ್ಟ್.
ಹೈಕೋರ್ಟಿಗೆ ಹತ್ರ ಆಗುತ್ತೆ ಅಂತ ಇಲ್ಲಿ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದೀನಿ. ಎಲ್ಲ ಒಳ್ಳೆ ಮೇನ್ ರೋಡ್ ಆದಂಗೆ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ.
ಅದೇ ಕರೆಕ್ಟು. ಅಲ್ಲ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಒಂಚೂರು ಸೌಂಡ್ ಪ್ರೂಫ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಬೆಟರ್ ಅಂತ.
ಸೌಂಡ್ ಪ್ರೂಫ್ ಮಾಡಕ್ಕೆ ನೀವೇ ಹೈಕೋರ್ಟ್ ನಲ್ಲೇ ಕೊಡ್ಬೇಕು.
ಅಲ್ಲ, ಹೊರಗಡೆ ಸೌಂಡ್ ಕೇಳ್ದಂಗೆ.
ಅಲ್ಲ, ಹೊರಗಡೆ ಸೌಂಡ್ ಇವಾಗ ಕಿಟಕಿನಲ್ಲೆಲ್ಲ ಸೌಂಡ್ ಪ್ರೂಫ್ ಗ್ಲಾಸ್ ಹಾಕ್ಸ್ಬೇಕಾಗುತ್ತೆ ಅಷ್ಟೇ.
ಅದೇ ಏನೋ ಒಂದ್ ಮಾಡ್ಕೊಡಿ ಸರ್. ಇಲ್ಲಾಂದ್ರೆ ಅದು ಆರ್ಗ್ಯುಮೆಂಟ್ ನೀವು ಆನ್ ಮಾಡ್ಕೊಂಡ ತಕ್ಷಣನೇ ಇಮಿಡಿಯೇಟ್ ಬಂದ್ಬಿಡುತ್ತೆ ಸೌಂಡ್ಸ್.
ಹೌದೌದು, ಏನ್ ಮಾಡ್ತೀರಾ, ಇಲ್ಲಿ ಮರಗಳಿದೆ, ಮರಗಳು ಕಡಿಯಕ್ ಬಿಡೋದಿಲ್ಲ. ಪಕ್ಷಿಗಳೆಲ್ಲ ಹಾರಾಡ್ತಾ ಇರ್ತವೆ, ಕೂಗಾಡ್ತಾ ಇರ್ತವೆ, ಏನ್ ಮಾಡೋದು.
ಅದೇ
ನಾನು ಅವ್ರು ಕಂಪ್ಯೂಟರ್ ಕಳ್ಸ್ಬಿಟ್ಟು ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ಸೌಂಡ್ ನ ಡಿಸೇಬಲ್ ಮಾಡಿಸಿದೀನಿ, ಆದ್ರೂ ಬರ್ತಾ ಇದೆ ಅಂತೀರಾ ನೀವು?
ಅದೇ
ಇನ್ನೊಂದ್ಸಲಿ ಚೆಕ್ ಮಾಡ್ತೀನಿ.
ಓಕೆ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು.
ಇನ್ನೊಂದು ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಇಲ್ಲಿದೆ ನೋಡಿ. ಇದನ್ನು 53 ಇದು ಕೊಡ್ತೀನಿ, ಇನ್ನೊಂದು ಕೊಡ್ತೀನಿ. ಎಷ್ಟು ಬರೆಯೋದು ನಾವು? ಓಹೋ, ಹಬ್ಬ ಬಂದಿದೆ.
ಎಷ್ಟು ಫೈಲ್ ಇಟ್ಕೊಂಡಿದ್ರ ಎಲ್ಲ ಆಟೋ ಶೀಟ್ ನ ಮನೆಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್ಗೆ. ನಿನ್ನೆ ದಿನ ತಗೊಂಡೋಗಿ ಮೇಡಮ್ಗೆ ಮನೇಲಿ ಕೊಟ್ಟು ಮನೇಲಿ ಸೈನ್ ಮಾಡಿಸಿರೋದು ಮೇಡಮ್ ಬಂದ್ಮೇಲೆ ಅಲ್ವಾ? ಅವಳಂತೂ ಒಂದ್ ರಾಶಿ ಕೊಡಾಕ ಅವಳು ಸುವರ್ಣ ಫಾಸ್ಟ್ ಆಗಿ ಮಾಡೋದಿಲ್ಲ. ಇಲ್ಲೇನೆ ಅಲ್ಲ ಸುವರ್ಣ ಮೋಸ್ಟ್ ಆಫ್ ದ ಆರ್ಡರ್ ಶೀಟ್ ಅವ್ರದೇ ಅನ್ಸುತ್ತೆ.
ಆಶಾ BL ಅವರು
ಅವ್ರು ಇಬ್ರು ಇದ್ದಾರೆ. ಅವ್ರನ್ನ ಒಬ್ಬರನ್ನೇ ಸೋರ್ಸ್ ಅಲ್ಲ, ಏನೋ ಕ್ಲರ್ಕ್ ಲಾ ಕ್ಲರ್ಕ್ ಮಾಡ್ತಾವಳ ಅವಳಾಣೆ ಬದ. ನಾವೇನ್ ಅಂದ್ರೆ ಏನಾದ್ರು ಮಿಸ್ಟೇಕ್ಸ್ ಆಯ್ತು ಅಂದ್ರೆ ಡಿಕ್ಟೇಷನ್ ತಗೊಂಡಿದ್ದೆ ಬಾಯಿಲಿ. ಆಕ್ಚುಲಿ ಟೆಕ್ಸ್ಟ್ ನೋಟಿಸ್ ಮಾಡು ಅಂತ ನಿನ್ನೆ ಹೇಳಿದ್ವಿ ಅಲ್ವಾ ಪಾರ್ಟೆಡ್ ಆದಾಗ ಆ ಹುಡುಗಿಗೆ. ಮಾಡೇ ಇಲ್ಲ ನೋಡೋದು. ಏನ್ ಹೇಳಿದ್ರೆ ಕೇಳಿಸ್ಕೊತಾರಿಲ್ಲ ಅಷ್ಟೇನೆ, ಬರ್ಕೊಳ್ಳೋದು ಇಲ್ಲ. ಒಂದು ಕಾರ್ಡ್ ಲಿಸ್ಟ್ ಇದ್ರಲ್ಲಿ ನೋಟ್ ಶೀಟ್ಸ್. ಆಕ್ಚುಲಿ ಅವತ್ತು ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಅಂತ ಬಂತು, PS ಕೃಷ್ಣ ಕಿಶೋರ್ ಅಂತ ಹೇಳಿದ್ರೆ ಕೃಷ್ಣ ಕಿಶೋರ್ ಅಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್ ಏನೋ ಮಾಡಿದ್ದಾರೆ ತಾನೆ ಮೇಡಮ್, ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ ಏನೋ ಮಾಡಿದ್ರು. ಅದಕ್ಕೆ ಈಗ ಸ್ವಲ್ಪ ಫೈಲ್ ವಕಾಲತ್ ರೀತಿ ಮನವಿ ಕೊಟ್ಕೊಂಡು
ಈಗ ನಾನು ಮಧ್ಯಾಹ್ನ ಅಲ್ಲಿ ಬರಿತೀನಿ, ಈ ಕಡೆ ಬರಲ್ಲ.
ಬರ್ಬೇಡಿ ಬಿಡಿ, 4 ಮ್ಯಾಟರ್ ತಾನೆ ಅವ್ರನ್ನ ಕೊಡ್ತೀನಿ.
ಯಾಕೆಂದ್ರೆ ಈ ಕಡೆ ಬಂದ್ರೆ ನಮ್ಗೆ ಮತ್ತೆ
ಬೇಡ KA ಹೇಳ್ತೀನಿ, ತೋರ್ಸ್ಕೊತಾಳ. ಅವಳೇ ಬರೋದಿಬೇಕಾ?
ಫೈಲ್ ಬರಿಬೇಡವಾ?
ಅಲ್ಲ ನೋಡಿ, ಹೆಂಗ್ ಕೊಳೆ ಹಾಕೊಂಡು ಕಳಿಸದೆ. ಕೇಳಿದ್ರೆ ಮೇಡಮ್ ಮೇಲೆ ಅಲ್ಲ, ಮೇಡಮ್ ಮೇಲೆ ಹೇಳ್ತಾರೆ. ಕೇಳಿದ್ರೆ ಮೊನ್ನೆನೆ ಸೈನ್ ಮಾಡಿಸಿದ್ರೆ ಆ ಹುಡುಗಿ ಬರ್ದಾಕ್ಬಿಟ್ಟು ಹೋಗಿರೋಳು. ಹೆಂಗಿದೆ ಗೊತ್ತಾ, ಭಾರಿ ಖತರ್ನಾಕ್. ಮೊನ್ನೆ 4 ಮುಖಾಂತರ ನಾನು ಫೋನ್ ಮಾಡಿದೆ, ಫೋನ್ ಇರ್ತಿದ್ರ ಇವ್ರು. ಈಗ ಡೇಟ್
ನಾಳೆ ಸೈನ್ ಮಾಡಿಸಿದ್ರು. ಇಲ್ಲಿ ಹಿಂದಿಂದೆಲ್ಲ ಆಯ್ತು, ತಗೊಂಡ್ರಾ?
ಮೊನ್ನೆ ಮೇಡಮ್ ಹೊರಟಿದ್ದೀನಿ, 4 ಮುಖಾಂತರ ಫೋನ್ ಮಾಡಿದ್ದೀನಿ. ಫೋನ್ ಇಟ್ಟಿದ್ದಾರೆ, 2 ಫೋನ್ ಯಾರು ಬೇಕು ಅಂತ ಇರ್ಲಿಲ್ಲ. ಬೇಕು ಅಂತ ಎತ್ತಿಲ್ಲ ಇಬ್ರುವೆ. 186, 187 ಕಂಟಿನ್ಯೂಸ್ ಆಗಿ ಟ್ರೈ ಮಾಡಿದ್ದೀನಿ 4 ಸತಿ. 4 ಸತಿ ಏನು ಒಂದ್ 20 ಸತಿ ಮಾಡಿದ್ನೇನೋ. ಆಮೇಲೆ ಕೊನೆಗೆ 864 ಫೋನ್ ಮಾಡಿ ಅವ್ರದ್ದು ಫೋನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆಯಾ ನೋಡಿ ಅಂತ 864ಗೆ ಅವಳು ಬೇಕಿಂತ ಇರೋಳು ಎಂಗೇಜ್ ಉಳಿತು ಆಮೇಲೆ
ಎವಿಡೆನ್ಸ್ ಏನ್ ಸಿಗುತ್ತೆ?
ಅದೇನು ಫೋನು ಇದು ಏನು ಯಾರು ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಡಿ ಅಂತ ಹೇಳಿದ್ರು. ಟೋಟಲ್ 25ರಿಂದ ನಾನು ಮಾಡಿದ್ದಲ್ಲ 5 ಗಂಟೆಗೆ 5 ಅಂದ್ರೆ ನಾನು ಫೋನ್ ಅದಕ್ಕೆ ನಿಮಗೆ ಏನು ಯಾರು ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಡಿ ಅಂತ ಹೇಳಿದ್ರು. ಫೋನ್ ಎತ್ತಲೇ ಇಲ್ವಾ? ನಿಮಗೂ ಎತ್ತಲಿಲ್ವಾ? ನಿಮಗೂ ಎತ್ತಲಿಲ್ವಾ? ಅದೇನೆ ನಾನು ಏನ್ ಗೊತ್ತಾ ನಿಮಗೆ ಮಾಡಿದಾಗ ಇನ್ನೊಂದು ಫೋನ್ಗೆ ಮಾಡಿದೆ ಅದು ಎಂಗೇಜ್ ಹೊಡಿತಾ ಇತ್ತು. ಆಮೇಲೆ ನಿಮ್ಗೆ ಮಾಡಿದೆ ನಾನು. ಅವಾಗ ನನಗೆ ಏನ್ ಅನ್ನಿಸ್ತು ಮೋಸ್ಟ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. ಸರಿ ಆಯ್ತು. ಯಾವ್ದ? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16,
11 ಡಿಸ್ಪೋಸಲ್ ಮೇಡಮ್.
16 ಹೌದು 17 ನಾಳೆಗೂ ಹಂಗೆ ಆಗೋದು. 17, 18, 19, 20, 21 ಹೌದು 21 ಇದೆ. ಯಾಕೆ 20 ಗೊತ್ತಾಯ್ತಾ? ಯಾವ್ದು ಬಂದಿಲ್ಲ ನೋಡು. ಯಾವ್ದನ್ನ ಡಿಸ್ಪೋಸಲ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಒಂದ್ಸತಿ ಲಾಗಿನ್ ಮಾಡಿ ಲಾಗ್ ಆಫ್ ಮಾಡಿ ಲಾಗಿನ್ ಮಾಡಿ. ಒಂದೊಂದ್ಸತಿ ಏನಾಗುತ್ತೆ ಅದು ಒಂದೊಂದು ಮೊದ್ಲಂಗ ಆಗೋದು. Number 2, serial number 4.
My lord, my senior is engaged in division bench, my lord. Kindly pass over the matter, my lord. Another 5 minutes he'll be.
List number 2.
2C number 4, my lord.
Serial number 4.
Who is appearing for the respondents?
Respondents, Mr.
Where is he?
Morning also was not present, madam. Last day we took time.
Then we'll pass orders.
We will not.
Arguments are required, I heard.
No documents are required. Yes, ma'am.
No documents, no arguments.
No arguments.
Yes.
Yes, it appears Krishna Swami has argued. I'm
Already
not-
argued. Your
Yes.
senior has already argued.
Argued.
So there are two. One is by the claimant.
Yes.
Give the order sheet. Let's see.
I don't know whether he has argued or not. One is. right in the-
Argued, I remember.
Then
At the request of one counsel, the respondent, list is matter on 15/4/2025. No further adjournment. Today, both in the forenoon and the afternoon, there is no representation on behalf of the land counsel, the respondent. List is matter tomorrow under the same caption. Yes. Next,
List number 2, serial number 6.
serial number
6.
Apologies, the matter was taken up in court hall 11. My senior will be in less than 5 minutes. May I kindly request?
because if the matter, if the court able to finish the list, it will come some other day. Otherwise, we'll hear it.
Great.
Yes, call the list, remaining matter.
Serial number 43. Serial number 43, pass over matter.
Your Lordship, I appear for respond number. Lordship, I kindly apologize to the court, Your Lordship. My senior had a doctor appointment, Your Lordship. Kindly alert one more time.
At request, list is matter on 24th at the request of land counsel for the respondent. Yes, next.
Serial number 48. 48, Gurudev Prasad KT.
No representation, list is matter after vacation.
Serial number 50, Shiva Reddy KN.
will be taken up next week.
ಇಲ್ಲ ಇದ್ದಾರೆ ಸರ್ ರಾಜು ಅವರು.
DL verification ಆಗಿಲ್ಲ. DL is to be verified.
Is this a matter came earlier also?
Yes, what happened, madam, they gave it now only. I've sent it to the company. He's little busy with, today he had evidence and we'll do it, madam, not an issue.
Finally, next week.
Please.
We'll decide next week on the
Next week
merits.
date may kindly be fixed, my lord.
25th.
Please, madam.
Yes, next.
Grateful for this.
Please.
Serial number 6.
Yes, next.
Serial number 6.
List is over.
Today there is no other.
Ladyship, this was the matter in which both the parents had agreed on a shared parenting plan. 15 days has been going on. In fact, we are willing for a wholesale settlement of all the disputes.
My lord, the seniors in the joint.
No, you have
is here, my lord.
whatever is the settlement, have you put forth to them?
Nothing, my lord. We haven't received any
had no
information as such.
Certainly, if they are.
No, what they're saying is they want a full one-time settlement. What do you say?
We are ready to talk.
Huh?
We are ready to talk.
Then
Certainly,
just,
very well. Please, I'm ready for it. Your Lordship.
No, if you're ready for a settlement, give them the proposal
Very well.
from your side. They'll come, they'll come with their own whatever they want.
Please, indeed, Your Lordship.
When you will give,
Within this week itself, Your Lordship.
and we'll post it after vacation.
No, my lord, there is something because there are some reports of the psychologist now. The younger child, that is the daughter, is having some problems. She needs therapy. All that we want assurance from them is.
No, it's
that
already order is passed
there was
that
an
they
order
should do it.
passed.
They're not doing it.
No.
Last
Now-
occasion,
Ah.
there was an order.
There is an
that
order.
Not even once, they should not know, the
Yes,
therapy
yes,
session, they
I've seen
shouldn't
that
skip.
order, yes.
And with whomsoever the child is, they should,
yes.
if by any reason, if that parent is not able to take, they should be given to the other parent,
Very well.
or vice versa.
The child has been taken whenever the children have been in my custody.
So what I'll do now is I'll say, with regard to the therapy, whatever the earlier order is passed, it shall continue until further orders. And within 1 week from today, the husband will come up with a proposal for the permanent settlement.
Yes.
Whatever you have, and we'll take up this matter on the reopening, after the reopening.
Lord, could it be just before reopening? Let two therapies happen sometime during last week of April.
Yes.
If I may kindly
List is
request for-
matter. on April 29, till this is matter on April 29,
If I
till
may
the next date of
apologize.
hearing, the arrangement that is made by this court with regard to the therapy sessions, which the daughter has to undergo, shall continue in the same fashion. Yes.
May I request for 23rd of April, Your Ladyship. 28th, 24th
too
to
early, actually.
29th, my senior would not be available.
28th then?
23rd, if I may request.
So how is it possible to give you
Just-
for
just
giving
one
the
week then.
proposal and for them to come back again with that? If you say that you can give it by tomorrow, then we can post it on 24th.
I'll do it in 2 days. I'll share my proposal. in
It
2
is
days.
submitted that by tomorrow, the counsel for the husband, it is submitted with the counsel for the husband, that within 1 or 2 days, they'll forward the proposal to the respondents. List this matter on 23rd is too early.
23rd is too early.
It's like
25th
having
prob-
it for the sake of it.
It's
When
about
is he
8 days.
leaving? When is your,
24th he's leaving.
Huh?
24th he's leaving, Your Ladyship.
oh, for the vacation?
24th to 29th he's unavailable.
After that
then-
vacation only.
After that,
Then it has to
after
be
that,
after
he's
vacation.
back after that.
Lord, there are two things. Lord. One, this month full maintenance he has not paid. Lord. He has written a email saying that I can't pay. Though he has changed his job and he has got into a much better job now. He has
Then
become a
what is the-
director.
Please understand.
Maintenance has been ordered, I will pay it, Your Ladyship.
Yes.
Maintenance, what has been ordered, I've been paying. I will
And
pay.
will continue to pay the maintenance.
Full maintenance.
As admitted before this, as
And
stated
Ordered by
before
this
this court.
as ordered.
As
Lord,
stated
and he
before
shall
this
also pay the therapist fees.
Therapy, Your Ladyship.
Therapist
And
fees.
therapy
Very
expenses will be borne by the husband, by the father.
Very good.
This matter, we'll have it after vacation. No point in having it before.
So let him come with the Lord, proposal. If something works out, we'll come and mention
We'll
it.
have
before
it
your Lordship.
on,
Lord,
23rd
Mr. Govindraj
is
is
of-
not required if there is a settlement.
huh?
Mr. Govindraj will not be required if there is a settlement.
Correct.
It may be had on 29th.
We'll say, let it be on 28th.
Yes.
By the time, whatever, like, if something is happening.
Happening,
Because
otherwise-
court will pass orders only basing on, by 28th, if any outstanding maintenance is there, shall be paid. And,
Given the relation.
and both the parties shall place before the court, if settlement, if any.
Yes.
My last request, if it could be 29th itself. If my senior is back by the first half, I will request him to
29th.
be there. Grateful, Your Ladyship.
Sorry.
Yeah.
Sorry.
For settlement.
29th.
29 ಪರವಾಗಿಲ್ವಾ?
The outstanding amount, if any, of the maintenance shall be paid.
It's been paid.
Not paid, it seems.
No, I've just got.
It's okay. It's okay.
Therapy sessions shall continue in the same fashion, and therapy expenses shall be borne by the father.
Therapy.
Expenses for the therapy shall be borne by the father.
We can make that continuous.
Yeah, arrangement.
Either.